Hey guys, we are
Hey,
dual streaming, so it's going to be a Defense Diaries and Cat Not Williams hybrid gang collaboration. To get us started off, we are going to be streaming this trial on a delay. You want to explain why, Bob?
yeah, hi, beautiful humans. So it looks like this morning the judge put out an order that they were required, Court TV and Law and Crime were going to be required to disable their live stream. So, in order to be in compliance with the judge's order, what we're going to do is we are going to watch the trial on a slight delay. Hold on there, cat's
I
going,
hear me.
cat's going live on my phone. So in order to be in compliance with the judge's order, what we're going to do is we're going to watch it on a slight delay, not just today, but we think probably for the entire trial will be on a delay. Kat and I are going to figure out exactly how long we'll delay it each morning, but we believe that that will be in compliance. That way, our chat isn't simultaneous to what's actually going on in the courtroom, and we believe that we will be in compliance with the judge's order, which I happen to think is a First Amendment violation anyway. So that's where we're
Yeah.
at. So that's what we're going to do. And in order to kind of build in a little time for my folks over at my channel, if you haven't watched Kat's amazing like 12-minute overview of the case, that's what we're going to do to kill some time. The trial has not started yet anyway. It looked like they were doing some housekeeping things. So for all of us, including me, it's going to get us caught up on George's case here and see what kind of the background is, factual, procedural, all the stuff that Kat always does. So I'm looking forward to it.
Sweet. So we'll roll that, and then we had some updates since I made this video over the weekend, and that should take us up to being nicely desynced with the contemporaneous stream. So we'll be off the screen for like the next, how long is this recap? It's like 12 minutes. And this will give you an overview of the case, you guys. Some of you may have seen this already, but if not, it will fill you in.
2026 in the Miami.
Oh, it will fill you in. Why can't I rewind? It's being funny. There we go.
The trial of George
All right,
Pino
and we
is
will
set
be
to
back.
begin with opening statements on Monday, June 8th, 2026 in the Miami-Dade Circuit Court before Judge Marissa Tinkler-Mendez. We'll be watching the trial here on this channel. Here's the backstory. On September 4th, 2022, Labor Day weekend, a 29-foot 2019 Robalo R302 center console boat slammed into green marker number 15 in the Cutter Bank Channel of Biscayne Bay near Boca Chita Key. 17-year-old Lucy Fernandez was trapped underneath the capsized vessel and drowned. Her classmate, Katy Puig, suffered a traumatic brain injury and lifelong disabilities. 11 other teens were on board for a birthday celebration. The man at the helm of the ship was George Pino. He's a Doral real estate broker and avid boater with hundreds of hours on this exact vessel. He had traversed the same channel at least 41 times in the prior 2 years and avoided marker 15 times since December 2021. GPS tracking showed that the boat traveled the equivalent of nearly 2 football fields on a collision course at around 47 miles per hour, with no sudden turns or course corrections until impact with the channel marker. Pino was the owner of this boat. Notably, it had a center console with 360-degree visibility and 2 Simrad GPS navigation units. It was equipped with 2 300-horsepower Yamaha engines capable of 54 to 55 mile-per-hour top speeds. During the September 4th, 2022 outing, George Pino, his wife Cecilia, their daughter Carolina, who was turning 18, and 11 of her friends left Ocean Reef Club around 2:52 p.m. They anchored near Billy's Point off of Elliott Key for nearly 3 hours. 4 boats total met there. The passengers of the boats reported that they helped themselves to alcoholic drinks from a cooler on Pino's boat, and that empties from the multiple boats were tossed aboard and later put into the live well. At approximately 6:18 p.m., the Robalo left for the return to Ocean Reef. Pino was at the helm. Nobody was assigned as a lookout. No one was wearing life jackets on the return trip either. The boat was yacht certified and exempt from the fixed capacity plate requirement. With 14 people aboard on this trip, every seat was filled and the boat had 7 passengers, adding significant weight. The boat entered the narrow Cutter Bank Channel, which has widths that vary from roughly 119 to 171 feet at the different markers. GPS data showed that Pino accelerated during this time, with average speeds in the upper 30s through the channel. Conditions were clear daylight, calm water, no storms, no obstructions. Channel marker 15 was visible on charts, on Pino's GPS, and had a large neon green sign. For at least 9 seconds, the vessel was on a direct collision course with the marker. It's estimated that the collision occurred at 47 miles per hour. The boat capsized and everybody was ejected. George Pino hit his head. He was briefly unconscious on the deck and then helped pull Lucy to the surface after being directed to do so. Lead Florida Wildlife Conservation, or FWC, investigator William Thompson, who's now a lieutenant and certified drug recognition expert, responded to the scene. He later wrote in his August 2023 incident summary report that Pino showed no signs of impairment when officers arrived or when Thompson interviewed him 1.5 to 2.5 hours later. Thompson concluded alcohol was not a contributing factor to the collision. A steering inspection found no pre-impact mechanical issues. Although at times George Pino claimed that another boat went by and caused a wake right before the collision, camera footage and witness statements show no other large vessel creating a wake in the minutes before the impact. GPS also showed no sharp maneuvers. Thompson's report noted Pino's familiarity with the area and stated that Pino did not operate in a reasonable and prudent manner and lacked due regard for all the apparent circumstances, but explicitly found his actions did not constitute reckless operation. The case was forwarded for review. Around this time in August 2023, Pino was charged with 3 misdemeanors for careless boating causing injury or death, but the families of the victims pushed for more information.
They really, didn't take the time or, didn't do their due diligence with this case.
There was definitely alcohol in the boat, and that wasn't really looked at too much by FWC.
The Miami Herald began reporting in the summer of 2024, highlighting that key Good Samaritan witnesses who helped perform CPR and saw the immediate aftermath were never properly interviewed. The attorney for the Fernandez family, Joel De Niro, located some of these witnesses. A firefighter by the name of Matthew Smiley ended up coming forward in the fall of 2024 after reading the articles from the Miami Herald and stated that he observed signs of impairment while helping George Pino that day. On October 31st, 2024, the state upgraded the charges. In an order signed by County Court Judge Lizzie Paget, the case was transferred and upgraded to Marissa Tinkler Mendez under its new number F24-022896. At that time, the 3 counts were vessel homicide in a reckless manner, operating a vessel without required USCG safety gear, and vessel having an expired registration for 6+ months. George Pino self-surrendered on November 21st, 2024, and was released on his own recognizance. A manslaughter count was later added in August of 2025, and on May 15th, 2026, the charges related to the expired registration and operating without safety gear were null-prossed, or dropped. While this is all happening on the criminal side of things, the Puig family reached a reported $16 million settlement with Cecilia Pino, and the Fernandez family started the Lucy Fernandez Foundation for Boat Safety Awareness. And as we approach the June 2026 criminal trial, there has been a flurry of motions. Here are the major motions with specifics from both sides. From the defense's motion to dismiss and the related replies that followed, the defense argued that there are no material disputed facts, and that the undisputed facts do not establish a prima facie recklessness or culpable negligence. They listed dozens of stipulated facts and cited Miller v. State and Jackson v. State on the difference between a momentary lapse/inattention and gross or flagrant recklessness that evinces disregard for human life, especially when the operator's own family was aboard. The defense's argument is that this was a tragic accident from momentary inattention or mistake of judgment, but not conscious recklessness. Even if on the wrong side of traveling fast with weight distribution issues, that does not meet the legal threshold when weighed against all facts, including his own loved ones being aboard. The state's response is that Pino was using a high speed in a narrow channel, that it was his failure to maintain lookout, that there were navigation rule violations, and that even if there wasn't a legal impairment from alcohol, there was still alcohol contributory context. The state also argues that there were missed opportunities to avoid the collision despite familiarity with the channel pathways and operation of the very same vessel that he's used many times before, and that the inherent drowning risk created a totality of circumstances that was reckless and makes Pino culpably negligent. They emphasized the predictable outcome and that Pino had ample time and means to avoid the marker. Judge Tinkler Mendez denied the motion to dismiss. The defense also filed a motion in limine to exclude alcohol-related references. They wanted to exclude evidence that underage passengers drank from the cooler on Pino's boat. They wanted to exclude evidence of the 61+ empty alcoholic containers recovered on September 6, 2022. And they want to exclude testimony from Smiley and the FWC officer Julian Gazzola about seeing bloodshot eyes and observing an odor of alcohol on George Pino. The defense's argument is that the lead investigator testified alcohol was not a factor and that he observed no impairment. Any probative value is substantially outweighed by unfair prejudice, and that the containers came from multiple boats. From the defense motion to exclude post-accident statements, the defense is seeking to exclude statements that Pino made about another vessel creating a wake right before the collision and relating to alcohol consumption. The defense argues that because Thompson directed Pino to be moved to a different officer, Officer German's vessel, and that another FWC officer, Keith Hernandez, was told to go with the boat operator and maintain custody of him at all times, and also with an instruction to smell him, that Pino was not free to leave. In other words, he was in custody. Thompson later interviewed him, and the defense argues that this was custodial interrogation without a proper Miranda warning, and as such, the statements are privileged. They also argue that these statements are more prejudicial than probative. The state's position is that the statements were spontaneous or made during accident investigation and not during custodial times.
I'd like to ask permission to draw your blood. It's up to you completely. You know, I had 2 beers. And it's not illegal to boat and drive. It's not illegal to drink a couple beers and drive.
I feel perfect in the way that my mind was. I mean, I know what happened. I've been operating boats forever. I've done that right.
The state says that some statements may be protected by privilege, but others are admissible.
And the defendant is the one who volunteers additional information. If anything was ambiguous in terms of a Miranda waiver, this is it.
And the judge agreed. The judge ruled the statements admissible on June 1st of this year. And now that the defense has to deal with this issue at trial, they plan to raise a traumatic brain injury / false memory argument and will call neurologist Dr. Diana Barrett. The state's also requesting special jury instructions on navigational rules that apply to boaters. They argue that jurors might know the rules of the road for cars, but might not know the rules of the waterways for boats, and that these rules are directly relevant to whether the operation of the vessel by George Pino that day was reckless and creates culpable negligence. The prosecution's expert, Paul Alber, who's a Palm Beach Police Department lieutenant, is expected to testify about navigation violations, wrong side of channel violations, how speed, weight distribution, distractions, and other issues can relate to predictable outcomes that could have been avoided. But that should be an overview of the major issues raised in pretrial motions. So now we just had jury selection wrap up on Friday, June 6th. Opening statements are scheduled for Monday, June 8th, which is when we'll be starting our trial watch. Judge Marissa Tinkler is also presiding over the Antonio Brown self-defense case, and she told the attorneys in that case, who tentatively have a stand your ground hearing scheduled for June 23rd, that this trial she's dealing with now, this George Pino trial, will be cutting up close to that date. So she's estimating about 8 to 9 days of presentation by the parties, and is hopeful that she'll be able to keep the Antonio Brown stand your ground hearing on track for the 23rd. So this is about a 2-week trial that we're expecting here. Now, I saw the Miami Herald report that the jury, which is a jury of 6, is 5 men, 1 woman, and that 4 alternates were selected. The alternates, there's 3 women and 1 man. And one of the jurors is apparently an avid boater. I also saw CBS News report that an incident occurred where one prospective juror told the judge that a different prospective juror was out in the hallway and was playing a news story out loud about this very case, about this George boat crash case, aloud outside of the courtroom somewhere in the hallway, and asking what year this occurred. And so the judge had to continue jury selection. And when the state asked last minute for a 1-week continuance after getting some late witnesses provided over by the defense, the judge was not with it. She said, "We are not delaying this trial."
I'm asking for like a week's continuance.
Tonight.
On top of that, Judge, yesterday, they filed discovery exhibits
I'll have to
at
consider
5:02.
Excuse me, I'll have to decide whether or not this witness, because of the late filing and the problems that it is now causing, whether or not I'm going to potentially exclude this witness.
I think that would be a reversible error, Judge, and I don't want to try this case
I
twice.
am not, let me tell you all, we are not delaying this trial.
And Judge Tinkler Mendez found that these late filings were willful violations of what Florida calls the Richardson Rule. So next up, we have the trial, where the jury will decide whether this was a tragic accident or something where there was criminal recklessness or criminally negligent operation of this vessel by George Pino. So everything you heard in this deep dive comes from research into the court filings.
You there, Bob? Come back, Bob. So that was a case
I'm
background.
here.
Yeah, all right. We are all here. You see, I got the Bob's Tech Wizardry.
Yeah,
Here.
I mean, you're crushing it.
I made sure not to leave that part out.
I mean, you have to put it in.
So we are more than 15 minutes. We're like, this says 14, but I queued this up like 2 or 3 minutes ago. So we are 15 minutes-ish off sync. So I think we are good.
I think we're good too. And that summary, that case summary is awesome. It's awesome. It really tells us all we need to know moving forward. This is going to be a case, another one where the light is going to be shining very, very brightly on law enforcement's investigation initially into the whole thing. And, it's going to be a thing. It's going to be a thing. So we'll see.
And that's exactly what I want to be able to comment on. And I feel like we're not allowed to contemporaneously chat about it.
I know, and it's going to be frustrating for people because, I mean, this is a nightmare scenario. Your daughter's 18th birthday, you have a bunch of her friends out there, and like I've been there. I've had my kids go out with, friends and their parents. And, if my kid ended up dead because my kid was out on the boat with an adult who was allowing all the kids to drink, and maybe he was imbibing himself, and my child ends up dead, I'm going to be pretty pissed, and ultimately at the end of the day, whether or not they're going to meet the elements of the crimes that he's been charged with, this is not open and shut. This is not open and shut.
Yeah, and guys, quick on that. Again, it's manslaughter and like reckless homicide with a vessel are the 2 counts in play here. Both are felonies. And it is not like there could have been a BUI, like a boating under the influence manslaughter, but that's not what the state opted to charge. They just went for like plain manslaughter. So those are the 2 charges in play here.
And if you guys are joining us late and you don't know, the judge ordered prior to court starting up today that there was going to be no live stream chatting. That was
like the chat can't be live.
Right. So our workaround, which we think is in compliance, we're going to delay so that we're not watching the trial live. So we're going to be behind, not just today, but every day. Hopefully that doesn't create an issue for Kat, especially because she's down in that jurisdiction and she likes to go into the courtrooms and she doesn't want to get in trouble by anybody. So, but I think we'll be fine, but that's what the delay is about. So we're always going to be behind time.
Yeah, it just means you guys can sleep in a little late if you're on the West Coast. So
yeah, sweet.
All right, so let's get started. This is like, I queued it up to right when they pivot to the judge and I saw captions come in. So we should be ready to go. Here we go. Day 1, Florida versus George Pino.
Let's go.
Full courtroom. With some spillovers in the next room.
Ladies and gentlemen, State of Florida versus George Pino. I'm going to ask parties to please introduce themselves.
Good afternoon, Your Honor. Laura Adams, Jonathan Ford.
All right, boost it a little bit, you think?
Yeah, a little bit.
Okay, let's.
First, on behalf of the state, we are also being assisted by a law school intern, his name is Laurie Adams.
Very well.
On behalf of George Pino, who is President Howard Strudnick, together with Mark Shapiro, Edward R. Molino, Janelle Gomez. Good afternoon.
Good afternoon. Good afternoon. Eloise, can you please swear in Mr. Pino?
Please raise your right hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
Let me go over some ground rules for everyone in the courtroom. See, we're a full courtroom. During the course of the proceedings, it's critical that no one takes a phone out. No one has a phone on. You can leave your phones on vibrate, please, but don't take them out. There'll be no photographs. There'll be no video recordings. Please abide by these instructions. Second, I'm going to ask if you could, because again, we're so filled in here, Renee's going to check, see if you can bring the temperature down. But, please, ladies and gentlemen, try to keep your movement to a minimum in terms of in and out of the courtroom, because it gets also distracting. People, you know, trying to work their way in and out of the rows. We will take breaks. We're going to be, I have some matters to address with the attorneys at this time. Renee's going to go up and get our jury. And Renee's going to get our jury. And while he's doing that, I'm going to address some matters with the lawyers. Ladies and gentlemen, it's also extremely important. Please, the jurors will all be wearing juror badges to identify themselves as jurors. Even if you might not recognize them as a juror in this case, if you see someone with a juror badge, please don't go up and speak with them. Please also, if you're having any conversations about this matter, make sure you look around and see that nobody wearing a juror badge might be near you and be able to overhear those conversations. So please find private places. I urge you to have whatever conversations you wish to have on anything about this case in particular. Okay? Please be very mindful, though, of the fact that it obviously takes time to select the jury. We don't want all of the work that we have all done so far to be for nothing. And all of you are, because this is a public forum, you're entitled to be here, but all of you are part of ensuring
public forum
that justice is served and that the proceedings are fair. And to ensure that, again, please, no contact with any of the jurors, not even a hello, which can be misinterpreted. You see a juror, they're in an elevator with you, get out of the elevator. Again, avoid all contact. When we take breaks, because you're bound to have some type of view of jurors that might be on this case. Again, please stay away from them. Okay? I urge you all to do that so that we're going to be in session for upward of 2 weeks. So it's going to require everyone's attention while you're at this courthouse, attention to that matter. I ask you all to do that. In addition, the proceedings are going to be televised, and there are already rules that I have discussed. We have our Zoom on. There is no recording. There are no photographs. And if you're in the Zoom, as I'm making these statements, please make sure you keep your camera off, no comments, and keep your audio off. My judicial assistant is going to be monitoring the Zoom, and you will be removed from the Zoom if you violate these rules.
I heard Cat Not Williams and Bob Motta have their chat on. We're not on Zoom.
Well, we won't hear her admonition for 15 minutes, so.
Cat is absolutely correct. I am no expert in maritime law.
Yeah, I said you guys are experienced lawyers, but you're going to learn something new at this trial, I
For
bet.
sure. 100%.
We learned what hot dogging is today.
What is hot dogging?
It's like showing off in a boat.
Oh, yeah. So just, you never heard the term hot dog? Like in sports? Yeah.
Like kindergarten stickers where it's like hot dog and it's like a thumbs up.
I think that more than anything, that probably just ages me. It's like like an old timey. He's a real hot dog out there.
Totally agree. Legal vices. This is so up his alley. Rest in peace.
Good afternoon, Your Honor. Just a couple of preliminary matters. First, the state of Florida is going to be invoking the rule of sequestration. I know that that would mean that witnesses will not be able to be in the courtroom or observe on Zoom or on any live stream, nor will they be allowed to speak with each other about the case. Of course, that has to do with evidence, so anyone that's here, I would not ask anybody to be excused from the courtroom for opening statements. But once the proceedings begin with witnesses testifying. I know we touched on the issue of the fact that Cecilia Pino, Mr. Pino's wife, is listed as a witness, both by the state and the defense. Unlike family members of the deceased that have a constitutional right under Florida's constitution as well as Marcy's law, they have the right to be here. I will tell the court I do plan to call Mr. Fernandez, Lucy's dad, and do not intend to call Mrs. Fernandez, her mother. I don't know if the defense is going to wish to call her. I was asked to accept some service for subpoenas for both of them, which I have done. They're both present. I would like to inquire whether or not the defense is going to try to exclude Mrs. Fernandez from these proceedings.
No, we won't.
Your Honor, the next thing has to do with some discussions that have been had over the last 24 hours or so. I've had conversations with Mr. Shrevenick as well as Mr. Shapiro.
If I could just interrupt. Those conversations need not be part of the proceedings today.
To the extent that I will reiterate that the state is still willing to have an open mind. If the defendant wishes to pose any kind of plea offer that would be acceptable, his attorneys know the range of what the state would be willing to accept. I'm still willing to consider that. If he does not wish to do that, I would ask if Your Honor would make an inquiry.
But we can certainly, if the court thinks it's appropriate, I can convey what the state is offering.
I have not made an offer and indicated a bottom line of what the state would maybe accept.
I'm not going to make any inquiry at this point.
Okay.
Unless there is some further discussion that I need to become involved and make it on the record inquiry with Mr. Pino, I'm going to decline to do so.
I just would not want to have a situation where if he were to be found guilty, that he would make an allegation that he actually wanted to engage in some type of negotiations, but for whatever reason, wasn't able to.
I think it's clear.
Okay.
Works.
Your Honor, there was a motion in limine regarding a couple of photographs of Lucy Fernandez at the hospital. I have two photographs that I intend to introduce into evidence today. They were previously provided in discovery, and they were part of a large email list of the state's evidence. I have copies of those available for the court to review because I would be introducing them probably through the state's first witness. So that in order to have a smooth transition from openings into that, I figured this would be a good time to address that.
Let me ask you, getting back, working backwards, on the opening statement, how long do you believe the opening will be?
Maybe 45 minutes or so.
Similar.
So it's likely that after the opening statements, we probably take a break anyway, so hold off on that. But you're not going to use anything. If you have that's the next thing. If you have demonstrative aids or anything you intend to use during openings, that'll look at down.
I've shown all of the demonstratives I plan to use for opening. They've all been pre-marked. Mr. Shrevenick advised he has no objection to the state using that.
That's true.
Can I see them?
Of course. May I show them though in order because I don't. Of course.
Very strange to not skip ahead when there's downtime like this.
Yeah.
I'm dying over here.
Have you been in that courtroom?
No, when I went down for the hearings, it was a different one, but this is where the Rashawn Jones trial 1 took place. It was the same.
What is that background? Is that like
I,
natural light, or is that like some kind of like behind the judge? It's wild.
I don't know.
Huh.
I'm glad that they have maps. You know, some of these trials are all about locations, where things happened and when things happened, and yet there's no maps. But they've got that handled, it looks like.
Yeah.
And what they did, you guys, if you saw in the overview video, there was like the spaghetti modeling of the different boat routes. They used the GPS. There's 2 GPS systems on the Robalo boat that this collision happened in. And they looked back at all the different routes that were still stored. And the yellow line that was kind of like an outlier of all those spaghetti models is the pathway that the boat took that day before it collided with the channel marker. So, pretty cool use of spaghetti modeling.
Here I lowered my mic. Is that better?
Oh, are they saying that you're loud?
Cody said I was loud.
Photographs for the day in question.
Okay, are we like even?
I went down to like the 80s.
All right, I'll say 1, 2, 3, and then you say 1, 2, 3, and then they can compare us. 1, 2, 3.
1, 2, 3. Wait, at the same time? Here, ready? Do it again.
Now Chicago says you sound perfect.
All right, go.
So there we go.
We did it.
Also, Georgia Catmon became a member over at Defense Diaries. We love to see it.
Yay. Aw, family hug.
Aw. We got Frank in here saying good morning, been a member at Defense Diaries for a month.
Hey,
Always
Frank.
good to see Frank.
Love Frank.
Oh, they got like a glossy map. You saw how glossy that map was that she was holding? Polished. We're going to show it, but it's going to get the glare off that background behind the judge.
Blinding jurors.
All demonstrative for your opening?
Yes.
Okay. Some of those may be admitted or not?
All of them I anticipate will be admitted.
Oh yeah, those are glossies. Wow.
Okay, let's do that.
I gotta learn which of the Shreeviks are the Shreeviks, but this is Mark Shapiro over here on the left.
And a enlargement of the defendant's written statement.
Okay.
The slime green highlighter.
Judge, just so I don't have to keep running back and forth, would Your Honor allow me to just line these up along there?
Absolutely.
They knocked him over. Shout out to Tay Biz, member of the KNW gang for 22 months. Always good to see you. Hope you're doing well. Tay Biz is asking, what's up, chat? You're like, is this the microphone that's picking everything up?
The fuzzy guy there? I hope not.
This is their system.
That does not seem optimal.
I've sent over to the defense 2 proposed stipulations to sign and enter into the record. One has to do with the body-worn camera footage of Mr. Pino being interviewed by Lieutenant Thompson, where we agreed to redact the statements that involved the request for or the decision not to provide a sample of his blood. And also one that represents the statement that the defense indicated they would agree to, which is that on the day in question, Mr. Pino's vessel was in proper working order. Okay. So at some point we can get those signed and admitted. Okay.
So it seems like they're redacting that part about refusing the
And the
blood
last
draw.
thing, Judge, is just, I don't know if all of the defendant's family members were here when I raised a concern about the amount of displays of affection between the family and Mr. Pino. I understand fully that they want to support their loved one, and I have no problem with that. But I think that public displays of affection, like what we've seen thus far, is not appropriate in front of the jury, or even in the hallways, things of that nature. I would just ask, and I've advised everybody on the side with Ms. Fernandez and such that throughout this trial we must maintain proper decorum, no outbursts, no anything like that, and they're not to have any interaction with any of the jurors. But I just want to make sure that there's no displays that are inappropriate for a courtroom.
Right. The only thing of that I need to respond to would be your last comment as part of the rules of the House for everyone. It's an understatement that this is a difficult proceeding for probably everyone in the courtroom. For whatever those reasons might be, this is a court of law. And I expect everyone will conduct themselves respectfully, appropriately, during the proceedings. If there is something that is disturbing or upsetting, please go outside. Avoid shows of emotion. Again, if that happens, it makes it not only very uncomfortable, but it's inappropriate for a jury to see any of that. And so I expect that kind of conduct from everyone in the courtroom. Please, no public displays of affection within the courtroom. Again, if you see anyone with a juror badge outside the courtroom, avoid them. And if you're in a private place, then it's much different. Okay? So anything that potentially could be causing influence to any of the jurors would not be proper. And I have Renee here, who obviously monitor the courtroom. I don't anticipate having any difficulties along those lines. Everyone can be used to respect each other's space here and respect the process. Okay. That's it for that. Mr. Shredden, what do you have?
Judge, over the weekend, there was another boat accident at the Cutter Bank Channel. I was informed that a father with 3 kids collided with one of the markers at a slow speed. The 8-year-old son was ejected, sustained a brain injury, significant brain injury. There was media attention surrounding it, at least on Local 10. And then there were the postings by folks about this case, people trying to correlate the event tragedy of this weekend having nothing to do with Mr. Pino and making comments about Mr. Pino. I want to make sure that our jury has no exposure to that kind of sarcastic remarks by the public to a tragic event. So I'd ask the court, when the jury is available, that you would inquire whether they've seen anything, even if it's not directly about the Pino accident. There was this other accident over the weekend.
I'm gonna, as I would do every single day,
Have you watched anything?
make that inquiry just overall about any information about this case or anything else that might be seen later.
Thank you. We had proposed last week, I had suggested to the court when we were doing voir dire that the court should consider instructing the jury on the nuances of the charges of manslaughter and vessel homicide. The court had read a few sentences, but those sentences didn't define the mens rea elements of the charge. For example, manslaughter requires, one, that there's a death, and second, that the death was caused by the culpable negligence of Mr. Pino. But the term culpable negligence, I submit, should be explained to the jury now so that they can process the facts and the evidence through the lens of what the law requires. Likewise, with vessel homicide, the court gave a preliminary instruction during voir dire, I believe, but did not define the term reckless manner. And the concern I have is that this is a case that, to many people, there could be confusion between civil liability and criminal liability, and I understand that the court has made a great effort to help the jury understand the difference. But in going into this trial and processing the evidence, we would ask the court to consider giving some more in-depth instructions now. So we submitted one for manslaughter, one for vessel homicide. And in doing that, what we did was we grabbed excerpts from the case law and we provided it to Your Honor in a red-line submission so you could see the verbatim quotes we took from the cases that we found. Now, one thing that's becoming quite evident to us is that the difference between culpable negligence and recklessness is terribly murky. And indeed, the Supreme Court of Florida in McCreary made it sound like culpable negligence, which is the manslaughter standard, should be a greater offense than reckless driving leading to death, the so-called vessel homicide charge. And of course, that would mean that if Mr. Pino is acquitted of the vessel homicide charge, he should necessarily be acquitted of the manslaughter. Table that for a moment. But yet, in the jury instructions, culpable negligence without death is defined as a lesser included offense of vessel homicide. And so you would think that would mean it's a lower burden of proof. And so there's a significant confusion, I submit, on these elements. I've given the court the best I can find in terms of sound bites that I'd ask the court to read to the jury so they understand this is not just about failure of ordinary care or simple negligence. The concept of culpable negligence is a significant issue in this case. It is the issue in this case.
Yeah, a whole
So
issue.
the court, I submit, should educate the jury on that now rather than having them sit here for 2 weeks not understanding what they're looking for.
Was there anything else other than
The only other thing we raised was a motion in limine on the issue of impairment. The court recalls, I'm sure, that we've been quarreling over the issue of blood alcohol levels and toxicology. It all stems from the testimony 2 weeks ago of Lieutenant Thompson and providing some opinion about how blood alcohol dissipates in a case where there is no blood alcohol. And our concern that that issue is being injected into the case about impairment when there is no evidence of impairment. In fact, the evidence to date is no impairment. And so
Improper
what we asked the
input.
court to do in our motion in limine is to preclude argument and insinuation about impairment, given that there is no affirmative evidence of impairment. Indeed, the witnesses that will be testifying, by my count, there are 8 of them who observed Mr. Pino either before the elision, immediately after the elision, or during the investigation an hour and a half later. All 8 of those witnesses who I expect will testify purposely looked at Mr. Pino and observed he was not impaired. I don't know which way the state is going. They at one point said this case is not about impairment, which I understand to mean that one's faculties are impaired in affecting their ability to exercise their normal faculties. And so I would ask the court to consider that motion. I don't know if the state intends to introduce that concept during its opening statement. If not, we don't need to address it now. If yes, I'd ask the court to consider that motion ahead of the opening statement.
Okay. Would you like to respond to the request for me to give further instructions to the jury other than what preliminary instructions I gave them during the voir dire?
I have a response, and I don't think that it is appropriate right now to instruct the jurors on the law, especially not on only a part of the law. When the jury instructions are given, Your Honor just simply gave the elements, which I think is appropriate, but going beyond that at this point in the trial is not. Moreover, the instructions that the defense has proposed, I'm not in a position right now to agree that the statements that they're making meet the threshold for giving a special jury instruction beyond what the standard instruction is. So I think that just as the court has reserved ruling on giving an instruction regarding the navigational rules and that all voters in the state of Florida must adhere to them, I think Your Honor should defer on these other special instructions as well, especially because they were only sent to me, I think, yesterday in the later part of the afternoon. So I
There's
understand.
there's two parts of it.
I understand that.
Let me clarify. We'd be satisfied for now with just the standard pattern instruction.
I think that was the first part of the request, and you responded to that. Okay. And let me say, while I understand your point, counsel, I'm not inclined to start instructing them, giving them definitions at this point. We'll come in, we're going to give opening statements. I think that whatever I instructed them on just briefly during voir dire was in order to select the jury, select a fair jury, understanding what elements of the crime are. And I think that is sufficient. I'm comfortable with that. Although I understand your request, I'm going to respectfully deny that at this time. But then you'll all review whatever the requested specials. I'll consider what you have in addition, the additional language, the red line, language, and I'm going to ask the state to look at it because the state is asking as well for special instructions because there may or may not be aspects of what we have in the standard instructions that sufficiently instruct the jury for this particular case. So you'll all be looking at that as we.
So they didn't talk about it here, but the state's asking for special instructions on like waterway navigation because the assumption is that most of the jurors, a 6-person jury, even though one is an avid boater, I heard, that it's not like rules of the road that you would expect the ordinary person to understand. So they've got this long list. It was like 12 pages of navigational special jury instructions. So
Yeah,
I see dog.
there's the guy. I think that Richard, the defense attorney, has a very good point with respect to having the jurors get instructed on the front end because it's that thing where if the jury has a misconception of what the law is throughout the course of a trial, and any lawyer will tell you, people form opinions early on in cases. I mean, people will form opinions during opening statements, so I don't understand what the judge thinks the harm is on the front end in terms of just kind of clarifying the distinction in terms of the negligence, the culpable. But I mean, it's pretty clear this is going to be a hard fought case in terms of the law and how it's applied. I mean, we can see that on the front end. I mean, defense counsel's on top of the game right now.
Yeah, and also quick question. Jordy's asking, is the avid boater a confirmed juror or an alternate juror? The way I read it, it was grouped in with the description of the 6. So my inference is that it is a confirmed juror, but I guess it wasn't explicitly defined as a confirmed juror. And there are 4 alternates. The culpable negligence thing I think is interesting too. We just recently watched the Alicia Andrews trial, and she was convicted of manslaughter as a lesser to a top charge of first-degree murder. And the defense requested special instructions, and the jury had questions about culpable negligence and if it applies to second-degree murder, which was also lesser included. So it's something that juries, especially in Florida, seem to have some confusion on based on the model instructions that are sent back. And we've seen that recently. So,
and I mean, his point's well taken in terms of it being a murky area, and when it's a lesser included and it makes it appear that the burden is lesser in terms of culpable negligence. I mean, that's problematic for a jury to try to understand that. You know what I'm saying? It's any case wherein the jury instructions aren't abundantly clear. To me, it's a problem. I mean, the jury really needs as best they can to understand what the instruction is and what law applies. And if it's like a murky area there, you're almost going to be guaranteed that when the jury goes out, there's going to be a question or two that's going to come back during deliberations because they just didn't understand it. It's like that thing where, I wish that there was a class that jurors had to take, like a 2-hour class prior to serving on a jury, just so they had the basic understanding of the concepts of legal jurisprudence in this country, starting with the presumption of innocence and then moving forward from there, but just giving them kind of like a base baseline understanding of how the law operates. But maybe someday that'll happen, Kat. I'm not going to hold my
Yeah.
breath though.
I zoomed out. So the chat is saying, Kathy Roussan with Law and Crime is saying that they think that there might be a concern that their live feed could get kicked because of other chats being available. So what do you think?
I don't know. I mean, we're not live. Like,
But
isn't that a
what
fair
if
distinction?
but what if without it being reasonable, what if just because we're doing it, Law and Crime and Court TV, I mean they're the same now, get kicked?
What if I mean, here's what my problem is. I don't know what her rationale behind doing it was. Was it so that on replay crew that people can't go in like after court today and read all kinds of inflammatory chats? I don't know who brought up the issue, if it was the defense or the prosecution or just the judge on her own. I don't know. I mean, I don't want to get the stream crushed, but to me, we're in compliance. But I don't know what the rationale behind the decision was. You know what I mean? If it's because we clearly heard defense counsel saying, look, there's been all kinds of chatter on the interwebs over the weekend talking shit about my guy. It's like, I don't want jurors to be able to kind of like run into that kind of stuff. But I don't know. Yeah, I mean, Law and
And I don't
Crime.
see an order on the docket, but I mean, it might not just be posted to it. So I can't see what it actually says.
Yeah.
So, or what was said.
I mean, it's your call, girl. It's your call.
All right. Well, here's what I think we should do. We'll keep going, but let's read in case we have to like shut off. Like, let's make sure we say thank you here. So I want to say thank you to Tay Biz with the 20 and the all love. So big thank you there.
Big
Over
love.
on Defense Diaries, we had At for Dread. Always good to see. Says
Yes.
a trial I can relate to being from Key West. So you're just a little bit of a ways south there.
Yeah.
We have KLB becoming green. Thank you for joining the gang.
Aw.
We've got Sheriff Chuck dropping 5 gifted subs saying, look, we are going to keep the commentary going. We are not going to be shut out from commenting on a public matter.
Love
And
it.
we've got Paula here becoming a member, turning herself green over on Defense Diaries.
Aw, family hug.
I start this from DB, who mentioned that the defense attorney, Howard Shrievnik, has won a cert at SCOTUS. Crazy
I called him
resume.
Richard. Thank you, DB. You know why? Because he reminds me of the guitar player for the Rolling Stones.
Oh, okay. It's from the back of the head. That's how you recognize people. But yeah, so the guy we saw doing the arguments at the podium, Howard, Richard, whatever we're going to name him, is who we're talking about here. We also have, let's see, Larisha, I think is how to say it, over on Defense Diary says, had no idea about this tryout. Thank you for streaming. Well, we are trying. I think the idea that we have a poor investigation, I mean, I'm interested in seeing like a boating case, right? I want to learn, but I'm interested in, did the FWC, the Florida Wildlife Commission, the investigating agency, did they do a good job?
Right.
And not for nothing, but for the state to try to hint at the beginning that they gave a minimum range of what they'd accept for a plea. I feel like that's them not wanting to confidently go ahead with this case in the public eye.
Yeah, can I ask you a question? So you said that this took place, like the actual accident took place and it was still daylight out? Is that?
Yeah, it was like 6:40-ish p.m., but it was Labor Day, so it was still, the sunshine is out late.
Yeah.
And they said there was no, like, it wasn't like a wavy, stormy day or anything like that. Everything was clear.
The only reason I ask is because when we saw that small clip of look like body worn cam on your recap,
They got there at 8 something, and there's
Okay.
actually the Puigs in their civil suit. They named both of the Pino parents, husband and wife, so George and his wife Cecilia, but they also named, I forget the names of the company, but the company that brought the helicopter out to airlift victims, and also the responding, like the first responders. They named them in the lawsuit because their response times were so late that they didn't even start to dispatch a helicopter until like 8 p.m., even though the first calls came in at like 6:50 something.
Okay.
So there's like an issue with the delayed response time that could have, Katy Puig she's got life-altering injuries, but maybe if she'd been intubated sooner and gotten oxygen back to her brain, that wouldn't be the case. So there's been a lot of concerning things surrounding this case, and I really think it's unfortunate that there's a risk of not being able to watch it. So
should I tweet at Kathy Russin and ask her what her opinion is? She's like,
does she know exactly what the order says?
I don't know, but I mean, I can try to hit her up on Twitter. She's usually pretty responsive.
Yeah, let's do that. Because
Okay.
I mean, I have no issue being delayed, and I thought that if you just didn't want a live chat, if you make the chat not live and contemporaneous, that would cure it. But maybe there's other language there.
Yeah, let me see. All right, let me.
And at for dread also with the context. And thanks for the super chat over on Defense Diaries. Says boating, especially down here in the Keys, is very dangerous. As the captain, you're responsible for everything. And a lot of folks just disregard it, get hammered. That's why a qualified captain is an elite follow. Oh, is that like a Instagram account that talks about this stuff? Like qualified captain is the name? Yeah, it's cool stuff. I mean, didn't really think about it until we watched the Cole Goldberg trial. It wasn't a boating accident, but it was after a day party, Boca Bash. 2 individuals are swimming in the water. One says the other attempted to drown her, but the other was like, no, I was just drowning and reaching for anything I could. So that was an interesting case as well. We've got Iris in Mexico. Thanks for becoming a member over on Defense Diaries. I know Bob is going to give you a group hug.
Aw, family hug.
And then we've got 10 new family members at Defense Diaries here from GP Dog Drool, which is a great name.
Thank you. We appreciate that always so much. All right, so let's see. How should I work? I said, Kathy, can you give us some clarity on the no live chat order by the judge in Pino? We cannot find an order, and we are curious if this would include if we were streaming on delay. Do you think that's clear enough?
Yeah, I mean, because the issue is that we can't see the order. The secondary issue could be Kathy could be like getting word of the order from her camera person who maybe doesn't know explicitly what the order was. So Kathy could kind of have a secondhand interpretation from someone who might not be familiar with the legalese, or maybe they are.
All right.
Because to me, it just seems like not a hashed out order to just simply say no live chat.
Yeah. Google said no comments and no chat feed. Yeah, but there's a distinction here. Like in the distinction, as there always is in the law, there's interpretation of what's being said. We're not live streaming. Now, I mean, some could argue that's semantics. I would argue it's facts. We're not. But again, like we don't know what the rationale behind the decision was. If it's we don't want to have chats enabled so that later in the day, if a juror decides to break the order of the court in terms of not viewing any kind of content online, and they run into, say, our channels and they see our chat, and that in some way, shape, or form that influences them improperly. I don't know if that's what the rationale is behind it.
Like, is it literally just the YouTube live chat feature?
I don't know.
Because, like, what if someone just, like, posted on a Twitter thread and everyone just replied to the same home-based Twitter post?
Right. That's right. Exactly. I mean, it's a very broad, it smells like the Aaron Spencer gag order kind of in some types of ways, like where the judge is basically gagging the world about talking about the case. So, all right, I sent this off. I'll see what Kathy says.
All right. So, and guys, the issue is not... The issue is people are saying, like, look, they're streaming opening statements right now, and you guys should be fine. My concern is Kathy's saying that their in-court camera feed could be nixed by the judge if other channels have their live chats enabled while watching this case. And we might disagree with that, but that does nothing for us if everything is yoinked.
Exactly. So Kathy, 18 minutes ago, posted FYI to any other YouTubers using the George Pino stream. If you have your chat room enabled, there's a good chance our camera will get kicked out or no longer live streaming. Strict order from the judge. So, and that was 18 minutes ago. And then therapist, tagged me on it. And then Bell tagged you on it. So, I mean, based on that, I can guess how Kathy's going to answer. She's going to err.
She's going to be on the cautious side of like.
Yeah. Hey. Thanks, DB. You had I'm reading something that you have on the screen. Okay.
Oh.
Yeah. Wow.
Yeah. So I don't know. To me, it's just like the conversation could continue on any other mechanism, but the issue is specifically a live chat attached to a feed.
Yeah.
Or like, what if you guys went over to X and use like a chat room over on X? Like, is that still the same thing as disabling a live stream on the video feed? What tech wizardry is this?
I don't know. It's like beyond my skill level of tech wizardry in terms of alternate routes. But yeah, because I don't know.
Why don't we cut chat today? Wait for an explicit order. We'll still have us on screen as commentary, and you guys. I'd be totally happy reading if you guys want to just like reply. We can read comments from over on X.
Totally.
And we'll take extra precautions today to make sure nothing happens with the feed. That if the feed gets cut, whether it should be or not, then we all cannot watch this trial. So,
right, which would be no good.
And I think. All right, Tech Wizard, I think you have to do this on your end for your YouTube stream. You got to go to your YouTube studio. You got to boot them. So is there anything you want to drop in your chat links?
Let's see, for like X.
Yeah, like do you want to like send people to a home base post? Should we make like a discussion thread?
Okay. All right. I like where your head's at. Okay. All right.
What if I just say George Pino trial chat is off?
Here, let me see. Wait. What do you? I want to. George Pino trial chat is off. Yes.
Live chat is off. So that's my official last words.
All right. So do you think that will encourage people to chat under that particular post?
I don't consider that's not a live chat. It's a post.
Right. Totally.
So
okay. George Pino live. Okay. All right.
And then you've got to go to studio. Sorry guys, this is a
yeah, it sucks, but I mean
Bob last night was like, do you want a dual stream? I'm like, this is gonna be great. I made a hybrid branding for us.
It's amazing.
And then they said hot mess.
All right. So, Kat, you might have to guide me through this because I don't know that I've ever disabled the chat. All right. So,
So what I'll do, we can start playing the trial and I'll call you and mute myself and walk you through it. Okay. So in a few minutes, guys, you guys will be, let's say thank you. Sheriff Chuck with another 5 gifted. Sorry to awkwardly speed through these. Thank you so much, Sheriff Chuck. This is an additional 5. Thank you. Thank you so much, Chuck. 5 new KNW members. For Dread is also green on both sides, part of both sides of the hybrid gang. And then we've got B. Got B in the 305 here with the 2 showing some love to Defense Diaries.
Thank you.
So we are going to resume, and this means that we could skip breaks for today once we kill the chat. You guys know what I mean. I'm not really killing you. I don't mean it like that. We can skip the breaks.
Yeah, true story. True story. We can get up to real time.
Yeah, so let me hit play here. I will mute myself and call you in a minute to walk you through your chat.
Thank you, Kat.
So that's the first part. What was the next issue was the question on in limine. Now, during your opening statements, I expect that you're going to be discussing what you believe the evidence will be.
Right.
And not making any arguments about the theory of your case or how the jury suggest how they should evaluate the evidence. So I wouldn't expect to hear from the state any type of argument on what is important, what might have been a contributing factor or not, but what the evidence will be. And I think I've already addressed at least in limine, the specific matters involving the evidence of alcohol. I think we've already done that in the last couple of weeks. So
It is my understanding, Your Honor, that the state is going to be allowed to talk about the fact that the defendant acknowledged that he had consumed alcohol and that he was seen consuming alcohol out on the sandbar.
that's going to be part of the evidence.
Yes.
So beyond that, if you have an objection, of course, anything that the state says during the opening, which should be what the evidence will be, and vice versa. If you have an objection, you'll make your objections and I'll rule on it at that time.
So that I'm not interrupting unnecessarily, we have our pretrial objections. I understand the court's overruling our objection to the references, the factual references to the alcohol and the 2 beers, so that you rule that I don't need to object again throughout the trial when that comes in.
Okay, well,
As you wish.
for purposes of making your record, in terms of a contemporaneous objection, not a problem, and I wouldn't find it as inappropriate if you made your objection.
So I can have a standing objection on that issue? Very well.
So I handle all that. Okay.
One more thing, Your Honor.
Yes, sir.
Good afternoon, Your Honor.
Yes, sir.
Your Honor, the defense filed several motions in limine. One of our motions in limine had to do with the exclusion of gruesome photographs and video recordings. Your Honor reserved ruling on that and said that she would take it up. We received from the state a videotape of a particular witness in this case, an officer Robalo, and one of the clips is specific with regard to the motion limiting to exclude this type of footage.
Okay, so this is, Officer Doral.
Yes.
Was he called as a witness for the state?
Yes, we don't know when.
Okay.
We're not told, but I did receive a video, and so I want to bring it to the court's attention before we got
For sure, but hold on, let me just ask the state. When do you anticipate this witness will be testifying?
Tomorrow.
Okay.
I miss you guys already, chat.
I so miss the chat.
Since we have the jury outside.
There's a huge hole in my heart right now.
And can you remind me, please, if there's something then objectionable in the video that the state intends to use during the testimony of the witness? Obviously, I want to look at it myself and see what that is. As I rule if it should be, further scrubbed.
Understood, Your Honor. Would you like a copy of the videotape that I received from the state this afternoon?
I don't have a problem. Would it be okay just if you email it to me?
Absolutely. As long as the defense doesn't have an objection, we'll do that during the break.
Of course not.
Yeah, that's fine. Okay. I'm making a note of that. That was still got it, right?
I'll spell that out. That's right.
Thank you so much, sir.
Lucy, one of the victims, her favorite color is blue. So I believe that's why we're seeing so much blue in the courtroom. That guy looks like he just got done voting.
It's probably exactly what just happened. Just got off his boat.
He's here from the case this weekend.
Ready?
Yes.
All right.
they doing this with the camera? Oh, Lord. That was almost an oopsie poopsie.
Oh, man. Is this all the jurors' footwear?
Wow. They did this in the Rashawn Jones case, too. They showed us all the, you know, like the cartoon characters that show Cow and Chicken, how the parents only had legs.
Everyone, please be seated. Thank you. Good afternoon, ladies and gentlemen. I'm going to ask Marilise, my clerk, to please swear you in as our jury. Please stand, raise your right hand and swear.
Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and the defendant and render a true verdict according to the law and the evidence?
I do.
You may be seated. Thank you. Ladies and gentlemen, welcome back. I have some questions for all of you. Have any of you seen or heard or read anything in the news that you think might have something to do with this proceeding?
Just in a live chat.
Okay. Have you seen or heard anything in the news about any other accidents in the water over the weekend? Or read anything about that?
No.
Okay. Have you been on social media, posted anything, read anything, online newspaper?
No.
Okay. Has anyone attempted to speak with you or in your presence about this case?
No.
Okay. All right, very well. Ladies and gentlemen, you have been selected and sworn as the jury to try the case of State of Florida versus George Pino. As you know, this is a criminal case. Mr. Pino is charged with 1 count of manslaughter and 1 count of vessel homicide, operation in a reckless manner. It is your solemn responsibility to determine if the state has proven that Mr. Pino has committed the crimes charged beyond the exclusion of a reasonable doubt. Your verdict must be based solely on the evidence or lack of evidence or conflict in the evidence and the law. As I explained to you during jury selection, this document in my hand called the information, that is the charging document. It was filed against Mr. Pino, but it is not evidence in this case, and it is not to be considered by you as any proof of guilt. It is my responsibility to decide what laws apply to this case and to explain these laws to you. It is your responsibility to decide what the facts of the case are and to apply the law to those facts. Thus, the province of the judge and the jury are well defined and do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys the opportunity to tell you what evidence they believe will be presented during the trial. I remind you what the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may be produced as evidence. After the evidence has been presented, the attorneys will have an opportunity to make their final arguments, and following the final arguments, I will instruct you on the law that is applicable to this case. After the instructions are given, anyone chosen as an alternate juror will be released, and the remaining jurors will retire to consider the verdict. I admonish you, you are not to form any fixed or definite opinions about the merits of this case until after you have heard all of the evidence, the argument of the lawyers, and the instructions on the law. Until that time, you are not to discuss this case amongst yourselves. During the course of the trial, we will take recesses and meal breaks. During these times, you're allowed to go about your personal business. You cannot discuss this case with anyone at any point while you are still on this jury and before you are discharged. You are not permitted to let anyone to speak with you about the case or in your presence about the case. If anyone attempts to speak with you about this case or in your presence about this case, please remind them that you are on the jury. If they persist, please report that to Renee immediately. This prohibition applies to everyone in the courtroom, the attorneys, witnesses, staff, and third parties. If you see us at any point outside of this courtroom, we're going to ignore you. And don't take that personally. All of us, everyone in this courtroom, is invested in maintaining the integrity of these proceedings. This case must be tried by you. This case must be tried by you only on the evidence presented during the trial and in your presence and in the presence of Mr. Pino, the attorneys, and myself. You must not conduct any independent investigation. You are not allowed to visit any of the places that may be described in the evidence or read or listen to any reports that might exist about this case. You are not to discuss this case with anyone. You may not speak with the attorneys, Mr. Pino, any of the witnesses, or anyone else about this case until you have concluded your deliberations and you are discharged. In every criminal proceeding, the person accused, in this case, Mr. Pino, has an absolute right to remain silent. At no time does he have a duty to prove his innocence. From the exercise of one's right to remain silent, you may not draw any inference of guilt or hold it against him in any way. The fact that the accused does not take the witness stand must not influence your verdict or enter your discussions in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure. They have a duty to make objections they believe are proper. When an objection is made, please do not speculate as to why it was made. Likewise, if an objection is sustained, which means I prevent a witness from answering a question or prevent a piece of evidence from coming in, please don't speculate as to what might have been said or what might have occurred had the witness been permitted to answer. Sometimes during the trial, and you saw it during our jury selection, it's necessary for me to confer with the attorneys in what we call sidebar conferences. I'm going to put on the white noise. This is not for your concern or consideration. It could be a matter of scheduling. It could be a matter of law, which is for me to decide. But I call these sidebars, or they might be requested at times during the proceedings. If I think that something might take a little bit longer than a few moments, I'm going to likely take a break at that time. Okay? I also try to keep sidebars at a minimum. So if counsel requests a sidebar and I ask them to reserve, it doesn't mean I'm mad at them. Many times I can anticipate what we need to discuss, and I might ask them to reserve and then handle it when we take a break. So I like to keep them at a minimum, keeps the flow of the proceedings going. Okay? In addition, let me talk to you about note-taking. Renee is going to hand to each one of you an envelope. Now, outside the envelope, there is a tab. There's a white tab on the outside of the envelope. Inside the envelope is a notepad and a pen. Please remove the notepad and the pen from the envelope. If you would, please, write your juror number on the white tab on the front of the envelope. This is how we will identify that envelope and that notebook as belonging to you. And that is your notebook to use, if you wish, during these proceedings. So make sure everyone write your juror number. These notebooks are not seen by anyone else but you. It's for you to use, if you wish. At the end of each session, and some at recesses, I may ask you just to leave them in your seats. If you take breaks, Renee may collect them during breaks. At the end of each session, Renee will take these envelopes from you with your notepads inside. They will be in a locked drawer in the office. No one will have access to them. Let me talk to you, though, about note-taking. I permit the jurors to take notes during the proceedings. And some people take notes, some people don't take notes. It's not a requirement. But the caution about note-taking is this. Please do not get so wrapped up or focused or concentrated on taking notes that you miss something. Because your job as jurors is to rely on your independent recollection of the evidence and testimony presented to you during the proceedings. So you have to be alert, you have to be listening, you have to be observant. So note-taking is fine as long as you don't let it distract you to the point where you're not listening, you're not paying attention, you miss something, okay? Because again, they're for your guide and they're used only to help you in recalling what transpired, to refresh your memory of what transpired during the proceedings. That's how notes can and should be used if you wish to take them. All right? Very well, let's begin opening statements.
Bob leaves and they finally start opening statements.
Your Honor, if I may just have a moment, please.
They just all set up. It's fine.
Thank you. Your Honor, may it please the court. Ladies and gentlemen of the jury, thank you for being here. Just by way of introduction again, my name is Laura Adams. Along with me is Mr. Jonathan Borst. And also we are going to be assisted from time to time through this trial by a law intern or law student who's interning at the State Attorney's Office, and his name is Juan Ramirez. This, ladies and gentlemen, is a case about responsibility and accountability. Or I should say, the lack of both on the part of the defendant in this case, George Pino. The evidence is going to show that on September the 4th of 2022, this defendant took his wife, his 17-year-old daughter, and 11 of her teenage friends out on his boat, and he wound up plowing right into a huge channel marker that ironically was placed in Biscayne Bay to keep boaters safe. As a result of his complete abandonment of good judgment and responsibility, 17-year-old Lucy Fernandez, her given name is Luciana Cristina Fernandez, is dead. In the aftermath of causing Lucy's death, this defendant avoided accountability by telling the police a fabrication of how this boating crash occurred. And he maintained that falsehood long after the day of this tragedy. The evidence in this case, ladies and gentlemen, will show you this was not a mere accident or a momentary lapse in judgment. The evidence that Lucy is dead because the defendant failed to do the most basic things that the rules of the water require. Things like maintaining a proper lookout. Things like operating your vessel at a safe speed for the conditions. Avoiding situations that can cause a collision, or as you may hear from time to time in this case, an allision. Collision technically means two boats striking each other. Allision is a boat striking a stationary object. Whatever term you want to use. Don't crash into things. Moreover, you are to travel when you're in a narrow channel on the right-hand side of the channel. We're not in England. We don't drive our cars on the left side, and we don't operate our boats on the left side of the channel. This defendant drove his boat after consuming alcoholic drinks that was full of teenagers who also had been drinking alcohol right into that big steel channel marker in Biscayne Bay in broad daylight, a channel marker that had a day glow green square above it with the number 15. A channel marker that he had passed by a multitude of times because this was his water playground going to and from a location, which I'll talk to you about in a moment, up to a sandbar. He hit that channel marker, ladies and gentlemen, as he was accelerating through the channel, going from speeds of 43 miles an hour to 47 miles per hour. He struck that steel channel marker at just under 50 miles per hour. The witness who will tell you how this crash happened has no bias, no prejudice, and no sympathy. This witness has a perfect memory. And this witness is not swayed by money or privilege or
It's gonna
power.
be a trial.
It's got to be a video.
That witness is global positioning system data,
GPS.
better known as GPS. The GPS from the defendant's boat is how we know the way that this crash occurred, because the GPS told the truth about what happened. George Pino did not.
Yeah, there's a picture of the channel marker real quick.
But before I get into the details of the GPS analysis that was done in this case, I'd like to give you a little bit of an idea of what was happening on September 4th, 2022. The defendant, George Pino, and his wife, Cecilia, had planned a wonderful weekend celebration over the Labor Day weekend. Their younger daughter, who was also named Cecilia Pino, but went by Little Ceci, named after her mom, she was going to turn 18 later that week. And so the family invited a bunch of Little Ceci's friends to come to a location called Ocean Reef Resort to have a weekend of fun, hanging out together, going out on the boat, having a celebration dinner. At around 2:52 that Sunday afternoon, they got into George Pino's boat. 12 kids, the defendant, and his wife. Before leaving for Ocean Reef Resort, before leaving the resort, however, that boat was stocked with some food and drinks. And the drinks that were stocked on that boat were not just water, or not just sodas. There was alcohol, lots of it stocked on that boat. Now the plan was to head out Can you want to see okay? The plan was to go from here, which is where the location of Ocean Reef is, where I'm circling this blue dot, and to traverse across this little narrow waterway, and then head up toward this location, which is called the Cutter Bank Channel. Now, for those that might not be boaters, what you'll learn in this case is that a channel is an area of the bay that's dredged out to be deep, because a lot of Biscayne Bay is relatively shallow. And if a large boat that has a keel under it has a draft that's, too far, that boat's going to run aground, and that'll cause a danger to everyone. So in areas where the bay is shallow, there will be dredged out locations. And to keep people safe and to let boaters know where they can maneuver their maybe larger vessels, there are what's called channel markers on either side. They're big steel poles, and on one side of the channel there will be odd numbered markers in day glow green, and on the other side there will be even numbered markers in red. The plan for that day was Mr. Pino went up through this channel, and he and other boats were going to rendezvous at this location here, which is called Billy's Point. It's a popular location where people will come to, dock their boats, tie their boats up to other boats, and people will socialize, have fun, sometimes drink alcohol, have food, listen to music, things of that nature.
Sometimes.
However, when they get to this area where I have the orange dot, Billy's Point, one of the boats that's kind of part of this group, it's too big to dock there. You can see where the water along here is, or this is like a lighter blue that shows shallower water. So what they do instead is they head up further north here to where I have this red dot. It's slightly deeper water, and that's where the defendant and several other boats basically stay for a few hours. Okay? So once they get to that part of the sandbar where the water is a little deeper, the plan was at the end of their time there, they were going to return back down to Ocean Reef because the defendant had planned a surprise party for his daughter. And it was going to be a catered dinner from like 9 p.m. to 11. to give you a little bit better of an idea of how the channel works, I have this exhibit also. And this gives you a little bit more of a close view of where the defendant was going to travel. So here we have where Ocean Reef is. Here is the area where he would traverse. And then this area here that I'm circling, that is called Cutter Bank. And there are channel markers, 15, 14, 13A. There's channel marker 12, all along this channel so that boats can safely travel through it, okay? And I have one more that's just a little bit closer so you can really get an idea of where those markers are through here. And all of this evidence you'll see during the trial. This isn't your only chance. When the defendant was traveling north to get up to where the sandbar was, he was traveling at a pretty moderate speed, maybe like in the 30s or so. Also, he was navigating the boat in a way that's consistent with seeing other vessels because, again, this is Labor Day weekend, and the waters are a little busier during holiday weekends than they are, during the business day. The defendant and the kids and his wife, all on his boat, get up to the area of the sandbar at about 3:23 that Sunday afternoon. Now let's talk a little bit about what was going on at the sandbar. There, Mr. Pino dropped his anchor, and the girls that were on his boat would, hang out with each other. There was another boat that was, the owner was friendly with Mr. Pino. He had some boys on his boat, so the girls and the boys were swimming back and forth with the boats, listening to music, having a great time. They would hang on to floating devices, interact with each other, and yeah, they were drinking. The teens on the boat, on Mr. Pino's boat, helped themselves to alcoholic drinks that the Pinos provided. The adults kind of knew what was going on, and the thought was, look, if kids are going to drink, it's better if they're drinking in the company of hopefully responsible adults, rather than do something on their own.
That's an argument, I guess.
But the teenagers weren't the only ones that had consumed alcohol that afternoon. So did Mr. Pino. This was really one big happy party. Here's a picture of most of the girls that were there that afternoon. Many of these girls knew each other from elementary school. What a great day this would have been. Oh. This girl here, in the white bathing suit with the cute little flowers, that's Lucy. At one point that afternoon, Lucy's mom and dad, who were also at Ocean Reef, had been asked by their daughter, Mom, Dad, come on out to the boat. We're going out with the Pinos. Come meet us out at the sandbar. Now, Lucy's dad, who you'll meet during this trial, he was kind of tired. He had golfed earlier in the day, but he and his wife figured, if your teenage kid is saying that she wants to see you, even when she's with a lot of her friends, let's suck it up, let's go. We're gonna go see our daughter. And so Mr. and Mrs. Fernandez took their own boat out and wound up rendezvousing with where the Pino boat was and a couple of the other boats that were there. What you'll learn is that Mr. Fernandez didn't really want to stay a very long time because he had plans later that day to watch the game between FSU and LSU with his dad, who lived at Ocean Reef. So his plan was to go out there, see his daughter, engage with the people that they all knew, and then try to leave by around 5:30 or so that he could be back in time to clean off the boat, get cleaned up, and then go over to his dad's condo on Ocean Reef.
But do you think George Pino was okay then?
While
when
Mr.
he left his
Fernandez
daughter?
is there, he too consumes some alcohol. He winds up
That's an interesting
toward the
question.
end of the day getting ready to leave.
It's 5:30.
And as he and his wife are getting ready to leave, they kind of thought about what a great afternoon it had been. They were glad that they'd gone out to see their daughter. At one point, their daughter swims over to the boat and she asks her dad for some sunscreen and a hair tie, to make a ponytail with her hair.
That's really sad. Like what if they didn't
She hugged
go
her
out
dad.
and see her?
Yeah.
Before
That could have been the
jumping
last
back
time.
off the boat. And that was the last time Andy Fernandez
heartbreaking.
ever got to hug his child. Before leaving, Andy took this picture with his phone. You can see this is the defendant's boat. You see people floating around. You see people on the boat. What could have been more fun than being lucky enough to be out on the waters, to have a weekend at Ocean Reef with friends that you've known practically your whole life? What a magical day this could have been. Now, they were there at that sandbar for almost 3 hours. And the evidence is going to suggest that perhaps Mr. Pino overstayed the time that he wanted to be there. Why? Because when he starts getting the girls to rendezvous back onto his boat, 12, 17-year-olds plus his wife and him, he leaves the area here. Where they had been, and begins to traverse back down south, where he's going to traverse through Cutter Bank Channel to get back to Ocean Reef. Why? I told you about him having a party planned. This was the invoice for that party. It was to go from 9 p.m. to 11 p.m. It was going to be a custom buffet with salads, mini burgers, chicken, all of this kind of stuff. It was an outdoor venue that was going to be catered, and it was supposed to be a great time. But, my goodness, he has 12 teenage girls that are going to need to get showered, get their hair dried, get ready to go out for this event. Now, these girls were staying in a home that the Pinos had rented for that weekend. It wasn't like some gigantic mansion.
I don't know if it's just,
What? What'd you say?
I don't know.
What happened?
I don't know.
Uh-oh.
Okay, it was just a momentary.
So what winds up happening is, as he's heading back toward Ocean Reef, he is going faster than when he was going up there. And when he was going up to the sandbar, we know from the GPS that he was kind of circumnavigating things like this. What we know from the GPS is that when he was coming back, he was doing a lot more straight through traveling. Now, the waterways, of course, are different from the roadways. We don't have speed limit signs in the same way on the water that we have on land.
And now it's super out of
But
sync.
there are rules that are to be followed.
Of course it is.
Even if there is no speed limit, one of the rules is that you must operate your vessel at a safe speed for the conditions. I already talked with you about the fact that there's a rule you are to operate your vessel on the starboard or right-hand side of the channel. George Pino operated his boat on a plane, which means that it's basically just skimming the surface of the water. He's gotten so fast that the boat is just traveling on top of the water. He's operating it on the port side, meaning the left side of the channel, not the right. And as he was going through that channel, heading back to Ocean Reef, just as he had his GPS on the way up, his GPS was on the way back. The GPS on his boat tracked his every move, his direction, when he changed direction, and it tracked his speed. The GPS on his boat was like a silent witness, watching and recording his every move. So you'll learn in this trial a little bit about how GPS works. For now, I will just leave you with this.
Oh no.
Oh man.
Oh,
Oh no.
it's gonna do this to us every few seconds. Watch.
Oh no.
It comes back. I don't know when though. Oh,
Oh
oh,
man. Oh boy.
oh.
Oh no. Oh no.
Oh, they're trying to take us down.
They're trying to shut it all down.
Can tell you moment by moment where the boat is going, how fast it's going, and how long goes by from one time when you change direction to the next time you change direction. So what winds up?
Sucks.
Oh, I miss the chat so much because I know they'd be like, no, and then yay every time it came back. And it would just be like this constant ebb and flow in the chat.
And you know, the worst part of it is it's like the most critical part of the opening.
Yeah.
Like when he hits the
On the way
channel marker.
to, yes, this is the GPS data that we have from the defendant.
Okay,
heading
why didn't they blow this
before
picture
he
up?
leaves.
They have a whole poster board. They could have turned the picture landscape and filled the whole poster board. Why is this one so
Huge.
tiny?
Exactly. Like the most critical picture.
They tried.
Heading up this way
Glossy.
to where Elliott Key is, and then you see these little like track mark, these little blue dots. Those are track marks. Those show every time the boat is being changed in direction. This is where he originally gets to at Billy's Point, but it's too shallow for one of his friend's boats to be there. So he heads up further north until they get right here. Then, and he gets there at about 3:47. From there, the GPS is turned off because the boat's anchored. What do you need your GPS for? At 6:18, the GPS is fired back up again. And we know, track mark, he's navigating his way through here. And now look at what we see here. Straight lines, track mark, straight line, track mark, straight line. A very different driving pattern to get back than to get up there.
Do not make track mark a drinking game.
So, what do we know happened?
Oh no.
Oh my God.
As
Terrible.
once he starts entering into Cutter Bank. We know that he is going straight down this way.
Look at these
Right?
giant clips.
There's a channel marker here, channel marker 14. Here is channel marker 15. This would be the channel, and he's hugging the left side of that channel. And what we know is that before he gets to channel marker 15, right, at 6:37 and 28 seconds, he has his last track mark. That's the last time he changed direction. And what did he do? He tried to avoid channel marker 15 right here. But it was too late. Let me back up a bit. So here we see the defendant's track lines heading up, and here he is coming back on the return track. And we see one track point here and one track point here, which is less than 30 feet away from where that channel marker is. And what we know is that when he leaves this track marker, he was going 43 miles per hour. This last track mark, right before he hits the channel marker, he's going 47 miles an hour. He's literally accelerating through that channel. What is this? All these little track marks here? This is after his boat crashes into the channel marker. Because he was not wearing a thing called a kill switch, which you attach like to your waistline or something so that if
All right, I'm sure the defense will clarify this, but I looked this up and it is not a requirement for a boat that is longer than 26 inches long to have an emergency shut-off device in Florida. And his boat was 29.
26 feet?
Yeah, sorry.
Oh, okay. I was like, wow, that was
Teeny
like
tiny boat.
the smallest boat of all time.
The switch couldn't even fit on that boat. But yeah, so she's arguing that and it sounds really crazy. And I was like, oh, is he supposed to? But I looked it up and actually he's not required. So I'm sure.
The thing that I keep wondering is if the girls, because that's a lot of people for.
Yeah, that's
not
what
a
I think
huge
is
boat.
negligent.
Right.
I have, if we can't see the image, if they show one of the seating chart, I'll load one and pull it up if she doesn't have a poster board where we're able to see it clearly of how you kind of saw it in that last photo that the
Yeah.
parents had taken. How many people, if all the people in the water were also on the boat, that would have been a crowded boat.
And
But
I'm
because it's
curious
yacht
if they were
certified, there's no
standing.
capacity.
Yeah. Like if like what happens, like I'm curious if the girls at that speed, I doubt it, but I mean they could be like standing. I'm just wondering if his view, like if he wasn't looking
Was
straight at the
obstructed.
view, was obstructed by the girls standing in front of him, because it looks like the largest portion of the seating area was up towards the front of the boat, right? That's where you had like that
Yeah,
kind
and
of.
that's where most people were seated.
Yeah, I don't know. Well, we'll find out as the trial progresses, I hope.
If we can't see any of those graphics when they show them, I'll pull some up on screen at that time.
you get ejected from the boat, it kills the engines so that nobody will get chopped up by a propeller.
Ew.
Thankfully, even though he was not wearing a kill switch, which is why we see the boat is still moving because the engines are still running, thank goodness nobody got chopped up in this case. To give you an idea of what it looks like for a 29-foot center console vessel to smash into a steel pole as fast as George Pino did, what you'll learn in this case is that we all have to talk like sailors a little bit in this case, all right? So starboard and port, right and left. So this is the starboard side of his boat. And what happened is he initially hits with the front of the vessel right here called the bow.
Camera's trying to show us.
Boats, unlike cars, are not made of metal. They're made of fiberglass, which is plastic. And unlike metal that crunches and crashes, plastic flexes. So when he first hits that, the boat flexes. And what winds up happening is the boat rides up on the channel marker and literally is gouged open by the board that's at the top of that channel marker that says 15. And it rips the boat right open. When it comes to the other side of the channel marker, it's taking on water like crazy through this gigantic, gash mark in the boat. And as the boat is in the water and taking on all this water, it flips.
Oh, they did a flip side. Look at
Upside
this.
down.
Wow.
So here's the flipped picture.
Wow. Holy shit.
This is a picture of the vessel at final rest. You can see that huge gaping hole in the boat.
I mean, that must have
Now-
been terrifying.
In the aftermath of this crash,
Especially if you were drinking.
Yeah.
it was chaos. The only person who was keeping a lookout for this vessel was the defendant. His wife, who was seated next to him in the center console, she was on her phone. The kids were all thinking that George Pino's going to get them home safely. They're not keeping lookout for danger. This all came as a shock to them. It should not have been a shock to the defendant because the evidence will show that 9 seconds prior to impact, George Pino changed direction just 5 degrees to port, just a little nudge to the left side of that channel. And when he did that, he was on a complete collision course. An absolute collision course with where channel marker 15 is. For 9 seconds, from this moment, when you're out on the water, as you'll learn in this case, you can see that channel marker ahead of you, if you're looking. For 9 seconds, he never changes direction. He smashes right into it. And to give you an idea of how long that is.
I was going to say. Sing us a song, Bob.
Well, how the whole world sings? Yeah.
That's how long he was on a collision course with that gigantic steel pole.
Yeah. I don't know.
After the boat hits the channel marker, some girls are ejected from it, some girls jump off the boat, but there are now 14 people in that water. One by one, the girls who were not too badly injured try to seek out and find their friends. The defendant's wife, same. The defendant, though, he just kind of holds on to the front of his boat, which is now upside down, and the anchor of his boat has become the canopy, because the canopy of his boat is now on the bottom of Biscayne Bay. One by one, they're trying to account for all the girls. Where's Ceci? Where's Katy? Where's Mia? Where's Carol? Where? All these girls. And eventually, through all that chaos, there are some that are not conscious, there are some that are borderline conscious. Everybody is accounted for, but one. They're looking and looking. Where's Lucy? Where's Lucy? Somebody yells to the defendant, still holding on to his boat. Look under the boat. Maybe she's trapped under there.
Okay, I'm going to put a picture on screen of the boat on the bottom of the water.
The injuries she sustained were not great injuries, but she didn't die from those injuries. She died because she drowned. She was underwater, unconscious, and she drowned. When Lucy's body is found, she's brought up onto a Good Samaritan boat. Because this was Labor Day weekend, there was a fair amount of vessel traffic out there. And without too much time going by one, Good Samaritans came and tried to help get all these people out of the water. When Lucy was brought on board, there were people on that little boat who started performing CPR on her. People start calling the police for fire rescue, for help. Now, it's tricky to give your exact location when you're on the water if you don't know how to give your coordinates, because it's not like you can look up and say, oh, I'm at the intersection of 12th Avenue and 14th Street. So sometimes it takes a little bit longer for first responders to get to the scene of a boat crash. Well, when the first responders get there, they know that Lucy is in dire shape. You'll hear that one officer, when he approaches, he's seeing a helicopter from above, which is trying to lower a paramedic onto the boat that Lucy's on. But the problem is the boat Lucy's on isn't very large, and the wash from the propellers is starting to make that boat spin. So he has to nudge his police boat up against the boat Lucy's on, and another officer has to do the same to keep the boat steady enough that it will be safe for the paramedic to come onto the boat. Once the paramedic is on the boat, they load Lucy up onto a backboard, and they transfer her to another boat. And then that boat takes off for this location here, Elliott Key, which is a long, really narrow island, and right about in the middle of it, there's a ranger station. And that's a place where it would be safe for a helicopter to land to then take Lucy to a hospital as fast as possible. Well, all along the way that they are trying to get her to Elliott Key, the officers are taking turns doing CPR on Lucy. The fire rescue guy is trying to intubate her. They're trying to get her heart pumping so that blood and oxygen will get to her brain.
God, what a nightmare.
As you can imagine, a scene like this is pretty chaotic. The man who was tasked with the responsibility of managing this chaos is named William Thompson. He was, at the time, an investigator with the Florida Fish and Wildlife Conservation Commission, better known as FWC. Since the time of this crash, he's been promoted and he is now a lieutenant. Lieutenant Thompson was responsible for coordinating with all the different responders that came to this scene. Officers from the Miami-Dade Sheriff's Marine Patrol Unit. There were Coast Guard officials that came to the scene.
William Thompson
there was other fire rescue units that came to the scene. There's the management of finding out who's injured, what's the level of injuries, conducting that kind of triage, figuring out what hospitals different people are going to go to. And beyond that, he also needed to find out what happened. How did this happen? The girls really couldn't give him any information. They're not paying attention, because what you'll learn is that on the bow of the defendant's boat.
Seems like the default for these guys would be to look for signs of alcohol consumption in general.
Up in this area here,
You know?
there was a girl sitting on every seat available.
We can look at their training
The
manual
defendant
for
and his wife were
think you'll like
sitting
it.
at the center console, and there were two girls that were seated in the back. These girls up front, their backs are to what's coming up ahead of them, and they're hanging out with each other, so they can't really tell what happened. And the defendant's wife was playing on her cell phone. So the only person that Lieutenant Thompson could try to find out how did this crash happen from was the defendant. Now, the defendant himself, for sure, got banged up. He had a cut to his head, a cut to his elbow. I think some of his teeth were, knocked around a bit. But overall, he was okay. He'd been checked out by police officers, fire rescue. He was ultimately transported to Elliott Key, which is where they brought all the other girls that were not tremendously injured. And there, Lieutenant Thompson winds up trying to find out from the defendant what happened. He could find out what happened from the defendant and from the GPS. And like I told you, the GPS told the truth, but he did not. When Lieutenant Thompson is interacting with the defendant, he's wearing what's known as a BWC, a body-worn camera. It's right on his chest. And while he's talking with the defendant at a picnic table that's there, the defendant is seated across from him. Now, you can't really see his face because it's like from chest to chest level, right? But you can hear what's being said. You'll hear the way that Lieutenant Thompson was speaking to the defendant in a calm way, just trying to find out what happened. Because at that point in time, there's no indication that this is a criminal case. They just need to figure out what the heck happened. So as they start talking,
always treat it like it could be.
the defendant starts explaining himself. But the way he does it was an abdication of his responsibility and accountability, because the evidence in this case is going to show that what he said happened did not happen. What he did to avoid responsibility and accountability is he told this story to Lieutenant Thompson that there was this other vessel that had thrown a big wake in his way, and to keep his passengers safe, he had to try to attack through the wake, like taking evasive action. But we know from the GPS, which Lieutenant Thompson didn't have at that moment, he was on a straight course. I showed you. It was for 9 seconds straight ahead. There was no other boat. He made this up because he didn't want to be blamed for what was clearly his fault.
Judge will reserve a motion.
Oh,
So
we'll add that to a mistrial
when
motion.
Lieutenant
Counter.
Thompson asks, how did the crash happen? The defendant tells this story about what the evidence is going to suggest is a phantom boat. Now, clearly, nobody's going to be fully in charge of their rational faculties after a horrific event like this, whether it's your fault or not. This is a really stressful thing for anybody to go through. And he was injured. But he was alert. He was able to walk around. He was able to be responsive to questions. When the defendant told this story of the phantom vessel, he then was asked, would you give a written statement about what happened? This is what he wrote. Going back to ORC, Ocean Reef Club, through channel, pass boat on left side of my boat. Veer to the right to avoid big waves. Coming back into the wave, I lost control of steering wheel as boat was going through the big waves. I was ejected from the boat. That's what he said happened. He said it in more detail orally to Lieutenant Thompson, but that's what he wrote. And even when the GPS proved that he was wrong, he doubled down on the things he said to Lieutenant Thompson.
I can't wait to watch a
Because
body
in the
cam on
aftermath
that.
of this crash, there was a lawsuit against the defendant. And you'll learn that in civil lawsuits, one of the
We'll hear
things
about
that
that on the
happens is
lunch
a civil
break
attorney
or the
may say
afternoon break.
to the person that they're suing, tell us about how this crash happened. And that kind of a document is called an interrogatory. And when you answer an interrogatory, your answer has to be under oath through the penalties of perjury even. And when he was asked in this interrogatory, how did this crash happen? You know what he said? What I said to Lieutenant Thompson, that's how the crash happened. How did the police wind up getting this GPS data? Well, in an effort to appear cooperative with the police, the defendant signs a form giving them consent to go on his boat and take from it the SIMRAD, that's the brand name of the chart plotter devices or the multifunctioning displays that he has. It's not completely unlike CarPlay, if anybody uses their Apple phone with their car, where you can scroll through different maps, charts, things like that. The defendant gives permission for that. And those SIMRAD navigational devices are then brought to a man who is, number one, a former FWC officer. Number two, is currently a lieutenant with the town of Palm Beach Police Department as an internal affairs supervisor. But also, number three, is a maritime expert who testifies regularly in the field of safe navigation,
He's an in-house
safe
law
boating,
enforcement expert.
requirements, and also in how to download and interpret GPS data. His name is Paul Albert, and you will hear from him about how GPS works, how he was able to extract GPS data from the defendant's boat, even after it had been upside down and underwater until they could salvage it and bring it back to shore. He will tell you unequivocally the defendant's boat took no evasive action to avoid striking that channel marker. There was no other boat in that vicinity. The defendant said that there was another boat, which is clearly disproven. He also told Lieutenant Thompson that he had 2 beers while he was out at that sandbar. Now, it would not be practical for you all as jurors to go out to the scene of this vessel crash and feel for yourself what it's like to go 47 miles an hour
Why would
through
you
that
say
narrow
that?
channel on the wrong side of it. So Lieutenant Thompson and Mr. Albert did the best that they could to try to recreate it for any jurors that might be on this panel, whether you have experience boating or not.
I feel like that's
What
kind
they
of hinting
did
to go
was,
see it.
using buoys and GPS points, they dropped one buoy in the Cutter Bank Channel where the second to last track point is, and one right before the last track mark, which is less than 30 feet away from where that channel marker is. They then had Lieutenant Thompson take his police vessel, which, like the defendant's, is 29 feet, has a center console, and has two 300 horsepower engines. And what he did was he then began coming through the channel, and by the time he got to where that second to last track mark is, he was going 43 miles an hour. He then continues to accelerate his vessel until he's at 47 miles an hour, and at the last second, swerves to avoid hitting the channel marker. To give you an idea of what that's like, we had a veteran crime scene detective with the sheriff's office come out on a Marine Patrol boat and launch
Really
a drone
recreation, then.
that then could film the boat as Lieutenant Thompson piloted
Definitely
it.
a recreation.
Like,
100%.
so you have two fixed buoys as a starting point and an end point to try to demonstrate an elision where someone didn't even try to swerve, but you're swerving as part of the reconstruction to reconstruct what happened.
Right. Plus, you can't. I'm sure the defense argued that it should not be admissible. I mean, how can you create the exact conditions that existed on that day at that time?
Yeah,
it's
probably
like-
way more variance than a road.
Yeah, 100%. And also, how are they disproving that there weren't any other boats on that water that day? I mean, it was Labor Day.
So what I saw is that they have a camera on a different channel marker, and they didn't see any large vessels pass by on that channel marker. But who's to say that a boat that passed on that channel marker wasn't hot dogging,
Right.
veering to the other side?
Right.
So, I don't really know. I'm assuming the defense is going to argue against that. But this is new for me, right? I'm trying to learn about maritime things happening on the water, but a buoy to me moves. So even if you're trying to reconstruct something and drive and accelerate towards a target, you're not going to be recreating avoiding something that's fixed.
Yeah, I mean, I don't know how much they move. I think they're anchored. Like, you know what I mean? In terms of
But it
they
looks like the
kinda-
chain can't be that long because the
Right.
boat could be on its hood and still have the bottom sticking up out of the
Exactly.
water.
And when you showed that picture of the capsized boat, like how
I'll
deep
pull
was
it up.
that water?
I'm actually surprised if she said it. I didn't catch her say it.
I mean, it looks like it's standable, right? Maybe. I don't know. It's weird. I'm
Wait, let's
curious
look
as
at
to
a full
how
picture of the boat on a lift. And then when they were standing, I feel like they were. Do I have a picture of them standing on the bow? Maybe. Is it this one? How tall are they on there?
I mean, tall enough to where they're blocking his view. Like that's my whole
And I
thing.
think the channel marker's like the size of a person. So,
Yeah, I
I
don't
mean,
know
I get
how
that it had a sign before the elision, I guess, and the sign must have fallen off during it. But if you just think of the pole, I can see how somebody
would miss it.
standing, because you mentioned it earlier, and I've been thinking about it. If George is supposed to be sitting in the cabin thingy, someone standing like how they are here could block that marker. I
Totally.
don't know.
Or multiple
So,
people standing. You know, like are there even enough seats for each of the girls? So 11 girls, the wife, and
so
George.
14 total.
14 total.
Yeah,
Yeah, I
and
don't know.
I would argue
Something
maybe that
clearly
is the
blocks
biggest
his view.
negligence, but
Yeah, right. That's a different question, but something blocked his view. Like that I feel pretty secure about. Like even if he had 2 beers, he's not shit-faced. Right? Like the guy seems he was trying to make a wonderful day for his daughter. You know, I think obviously his heart was in the right place. I don't think he would have gotten shit-faced having all those girls in under his care. You know, to me, it seems like he sees the thing at the last second because somebody was probably blocking his view. It's too bad that there wasn't like a boat cam on there so we could have seen what was going on, much like the dashboard cam in Spencer, which, by the way, somebody just tweeted at me, a new order is dropped and it is with prejudice. So that was good.
Well, that was the assumption, right? Because it was a due
Yeah.
process violation.
Yeah. Well, and
So
he clarified.
this is
it,
Aaron
so-
Spencer case, guys.
Correct.
So are you gonna? Well, I mean, it just was a little clarification or something that you guys would.
I mean,
stream
you
on
always
later?
want to see it in writing.
Yeah.
You know what I mean? You just want to, you don't want to have to make the argument, but, so yeah, I think the judge felt it was, the right move to just put it in writing.
Yeah, public interest, public misconceptions otherwise.
Yep.
So, all right, let's see how she continues to argue this reconstruction. And I do have some of these demonstratives. I couldn't tell which one she was relying on most of the time, but maybe we could go through some of these. And again, the yellow line is supposed to be like the route from that day that he took on September 4th, 2022. But the other routes are from his GPS from prior routes. So it's not like there haven't been other times where he's gone further beyond that like inner channel band where it's like the average route is in the middle there.
Yeah.
So I don't know, we could take some time looking at those, but I'm sure during testimony we'll have them on screen better than she's doing with the demonstratives.
And it
So,
looked
but
like
if not, we do have that.
Looked like he was port side on a couple of different occasions as well. Are those from different days?
So the spaghetti, the way they do it is, I think the yellow is just that date, and they don't give us a distinction on what the other day lines are.
But those
So,
are
but
the
I'm
other spaghetti strands are other days.
his boat, other days.
Okay. All right.
So, because from his GPS. So, but yeah, I thought that was interesting because she's describing it in openings as being an outlier, but I have those spaghetti models in my mind where sort of, but it's not the only time, right?
Yeah.
So it's not like this weird, unexplained,
Right.
whatever, and it always causes some accident. So, alrighty, let's get back to Miss Adams.
The channel.
Miss you, chat.
In addition, a
Missed you
GoPro
big time.
camera was affixed to the front of Lieutenant Thompson's boat so that jurors could get an eye view of what you could see if you're looking and when you can see that channel marker up ahead. In addition, a GoPro camera was attached to the actual channel marker so that you could see that same approach as Lieutenant Thompson comes right up to it and avoids hitting it at the last second. Now, lest you think that the police did all of this without concerns for safety, you will learn that during this exercise, there were marked police boats on the north and south end of the channel to make sure no vessels were going to be in that area. Plus, we had the Marine Patrol boat that the detective had launched the drone from. Plus, as Lieutenant Thompson was going through this channel, he had his police lights activated. In addition to that, everyone that was on board his vessel for this exercise was wearing a life jacket, or what's called a PFD, a personal flotation device. When you see this footage, you will realize that traveling 45 miles an hour through waters, even when they're calm, is nothing like going 45 miles an hour in a car. Boats are not encased in steel like cars are. They're not equipped with anti-lock brakes. They don't have seat belts or airbags. One mistake on the water can cause absolute catastrophe. Oh, and also, before this exercise, Lieutenant Thompson did not consume 2 beers. Now, although we can't take you to the scene of where this horrible crash happened for safety reasons, because you can't predict what the weather's going to be like during a trial, you will be taken on a field trip to the Florida Fish and Wildlife office, where they have a yard that they can store vessels that have been involved in crashes. And you will see with your own eyes this very boat. You will see the horrific damage, and you will be able to see for yourselves that anyone at the helm of that vessel, looking straight ahead, would easily be able to see a huge steel channel marker with a day-glow green board at the top of it.
How can you tell that by just seeing the vessel in custody?
There's no evidence to conclusively prove that George Pino was drunk. He's not charged with boating under the influence, causing a death. There's no evidence that he deliberately crashed his boat into that channel marker. If the evidence supported that, he wouldn't be charged with manslaughter and vessel homicide. He'd be charged with murder. But the evidence does support a finding that traveling through that narrow channel at the speeds that he was, with as many people on his boat as he had, people who had been consuming alcohol, people who were 17 years old, and not looking where the heck he was going for 9 seconds. People won't even drive blindfolded for 9 seconds. They sure as heck should not be operating a boat with a blind eye. The evidence in this case will show conclusively this was not just an accident. This was a bunch of factors that, when they all come together, form the inescapable conclusion that George Pino was reckless and he was culpably negligent, and as a result, Lucy's gone. And that's why at the end of this trial, I will ask you to return a verdict of guilty.
Maybe approach the motion before I start opening.
Sidebar?
They're going to sidebar the motion.
Sidebar.
Oh,
Ooh, white noise. Huh.
Ugh.
We who labor here seek only truth.
Do we? Do they? Only we can talk about it, though.
Yeah. What do you think the chat's doing out there? Just chatting?
No.
Oh man. It's a big punch to the gut to lose the chat. You know, it's like the community is the best part of this whole damn thing.
Yeah.
I mean, you're
like,
amazing, obviously, but like not being able to see our people and what they're saying.
Either us choosing to dual stream this is what cursed us, or it's a blessing in disguise, because at least we're not just sitting here like
reading chat.
Where's the chat? Oh my goodness.
I mean, I am definitely guilty of reading chat way too much. Like I'll miss like entire lines of questioning. Yeah. People like Ali will be like, "Oh, what do you think, babe?" I'm like, "Huh?" Sorry.
Yeah, sorry.
I was reading the chat.
But it's so good, because if you aren't sure exactly what you heard, the chat can give the context.
Always.
And figure it out.
All the time. Like if I miss a name with a new witness, I'm always like, "Chat, who was that?" You know, just anything. You know, if there's a debate on what was said, we can put it up and people, you know, it was like, what was there was a case where it was Rosemary Scapiccio, when she was like flamethrowing Proctor, and she's like, she said something, and I was fairly certain she said pass the butt. She was like,
what is this?
What is this? What is that? Who is that? Is that the same judge?
No, they took us to another trial.
What?
No, but it is Florida.
What? What is this other room?
It goes back.
Oh man,
Let's zoom
what
through
is
that.
this other room here to the right? To my right. What is that? Looks like there's a big sheriff's badge up there. Huh. Weird. There's some weird shit going on with this thing.
Maybe it's like arraignments or something.
Maybe.
All right, how much longer do they have this on the rung? Okay, they're still going to be at the sidebar. All right, so we could jump a little, but
oh yeah.
I don't want to miss them coming back, because sometimes they say some stuff. There we go. I see a bald head reflecting all the light from the backboard. I don't know. I think like kind of a strong argument. You got so many people on that boat, but then it's yacht certified, so there is no requirement to have a capacity plate, which kind of seems like maybe we should rethink that that standard here in Florida. Oh, we got instruction. Sorry. Let me turn the volume back up. And so we're getting a burden shifting instruction.
Ladies and gentlemen, let me just remind you that the state has the burden of proving each and every element of the crimes that are charged. The defense has no burden whatsoever to prove or disprove anything or present any evidence whatsoever. Thank you.
Good afternoon, ladies and gentlemen of the jury. Can everybody hear me okay? Is the microphone working, Your Honor?
I think it is.
I think we all agree that we're here today because there was a tragedy. Lucy died. And it's painful. It's painful for everybody to think about it, hear about it, talk about it. And over the course of the trial, we'll have to relive those moments. And George Pino is going to have to relive those moments. He loved Lucy. He'd known Lucy since she was a little girl. He loved Lucy like a daughter, like his own daughter. The state admits this was not George's intention for this to happen. He did not intend to crash into a marker. He did not intend for anybody to be hurt. His own daughter, his own wife, his own body was on that boat. He had traveled on that boat safely through that channel many, many times. Many times. And he was celebrating his daughter's 18th birthday with some of the best friends his daughter had since childhood. These were generational friendships. George's parents' generation, George's generation, and then the next generation. George would never think to put any of these girls' lives in jeopardy. And when he was traveling at 47 miles per hour, with everybody seated on that boat, with George at the helm, a perfectly clear day, the seas were calm. A boat like that could have been powered not with just 600 horsepower engines, but 700 horsepower engines, although George didn't put the maximum horsepower engines on that boat. That boat can travel in upwards of 50 plus miles an hour, fully loaded. There was no weight restriction or personal restriction that George was violating when he had all of his passengers on the boat. There was a life preserver for each and every one of them on board, although the law doesn't require that passengers on a boat wear the life preserver. There was no speed limit in the channel. And there are channels with speed limits. When you come back to port, you might see a sign that says, no wake. Wake, W-A-K-E. Boats have to travel slowly when coming back into port sometimes. There might be a marker that says minimum wake. And there are markers that have speed limits throughout the intracoastal waterway. But Cutter Bank Channel in 2022 had no posted speed limits. We are now in 2026. There are still no posted speed limits at Cutter Bank Channel. Even after this tragedy happened, our legislature has not imposed. There was none then. There is none now, because under ordinary circumstances, traveling at 47 miles per hour, which George Pino had done many times, is not a violation of the law. It is not unsafe seamanship. Still, George crashed. The state's theory, as you've heard it today, is a bit of a mishmash. On the one hand, they say to you 2 beers, trying to suggest to you this is about alcohol impairment. The state knows better than that.
Objection, arguments.
The evidence will show.
What the evidence will show. Thank you.
I apologize. Multiple eyewitnesses, at least 8, I expect, will testify at this trial, 8, who observed George Pino at the sandbar just after the collision, the crash, and law enforcement officers themselves who observed George Pino eye to eye, examining him purposely to determine, was George Pino impaired? Each of those witnesses who examined and observed George Pino were satisfied that George Pino was not impaired. That included the adults that were at the sandbar. It included Lucy's dad, who was at the sandbar, himself enjoying the festivities with his daughter, with the Pinos, and with the other families that were there. And the adults that were at the sandbar were also consuming some alcohol. They too operated their motor vessels after consuming some alcohol, including Lucy's dad. Lucy's dad would never have allowed his daughter to ride back with George Pino if Lucy's dad thought that George Pino was impaired. And Lucy's dad saw that George Pino had had a beer and was satisfied that George Pino was not impaired. This was not the first time George Pino had had a beer in his life. So you'll hear testimony from the adults at the sandbar, including George Pino's wife. George Pino's wife was on that boat. She would not have allowed her husband to operate a boat with her own life, her daughter's life, and the lives of the girls that Mrs. Pino had helped raise. Some of these girls grew up in the Pino home all the time, spending time together. Mrs. Pino will testify. George, her husband, was not impaired. She wouldn't have risked her own life.
Excuse me.
Again. Uh-oh.
I mean, he really did sleep. He's slipping into argument there. But, oh, man. Oh, this is what's going on.
That's why they're approaching.
Yeah.
Are they asking to approach because he's crying or because of the argument?
No, I think it's that.
Oh, man. What if he takes a deal because he can't handle, like he's
going through it. You can see it whenever they show him, like during, like you can see he's really, really laboring to breathe. He's got like, you know, and somebody was tweeting, they're like, well, like, why is he breathing like it? I'm like, people don't seem to understand that when you're sitting in that fucking chair, that it is the most stress-inducing scenario known to man. Like, there is nothing more terrifying than sitting in the defendant's chair during your trial. It just is. It's like you're, you know, I mean, the lawyers are feeling it too. I mean,
they're kicking the jury out. The jury is getting kicked out.
Oh, man.
As it should.
He's destroyed. He's destroyed. Anybody think he's faking?
No, I don't think he's faking.
He is definitely not faking. He is feeling every bit of this.
And like he really was like friends with.
Yeah, these
at least
were
from
like
the pretrial motions, they all knew each other.
Like these are, you know, I mean, I have a lot of kids, and you know, my kids play sports, and my daughters have friends, and we're friendly with their parents, and you know what I mean. It's just like, and you're talking about a decade plus of relationships.
It's all like wonky.
Thank you.
like 5
I
frames.
apologize to counsel. I have no intention of trying to interrupt his opening statement, but the defendant's emotional outburst became unavoidably distracting and wholly improper for a jury to view. Okay, I know it's not counsel's fault.
She says that as she wears a color for the victim.
Yeah.
You need to get a hold of yourself and be able to manage your emotions
How can you do that?
during these proceedings.
I don't know how you're able to, like, how are you supposed to be able to do that? If you're overcome by emotion, you're overcome by emotion.
It's going to be necessary. 10 minutes now. It'll take 10 minutes. Discuss how that can be accomplished, because we are going to proceed, and Mr. Pino is going to need to be able to control himself.
Jesus. I just...
10 minutes, thank you.
I'm certainly not of the position that could potentially influence a juror or 2 or 5 in terms of seeing him just destroyed. But the reality is,
There
how
were
can
people
you...
crying in the gallery too, visibly.
This
I noted
guy,
earlier.
Kat, this guy is like living the absolute nightmare. Like every day of his life, for the rest of his life, he's going to be filled with dread and regret about this day. You know what
Do
I
you think the
mean?
prosecutors are gonna like go to the defense counsel and be like, "Are you sure I don't want to talk to him about those offers, the range?"
I mean, like, I don't even think that's it. I don't even think that's it. Like, I think that, you know, the bigger question is there going to be any way that he can comport himself? You know, like I can just tell you, I'm a crier. Like at my wedding, you know, when I'm sitting
Aw,
there, like, you know, and I was trying not to cry.
like
Like I was
snot nose and everything.
the whole thing. I was like
Ah,
bawling. It was like insane. And like and I was fighting it. Like when I performed my daughter's ceremony last year, you know, I'm trying not to cry, but I'm like so moved. You know what I mean? I'm trying to get through this speech, you know, in terms of performing the vows and all that stuff and just the things that I had written. And it's like it's a really, really hard thing to do. I get from the prosecution's perspective why
I think it's undue
you,
sympathy.
you're right. I mean, but
But
the
like,
reality of the situation is, how do you control it? What is the other? What happens if George says, I'm going to do everything in my power to control myself? I mean, this is not me like trying to cry on cue. I'm
well, and
just
it's on the
overwhelmed.
flip side, you know, the state would happily prey on someone who sat there stone faced because their attorney probably told them like don't like react to certain things, and they probably try to
100%.
say like they don't have remorse, they're not remorseful. Look at them,
Right.
like
Stone
so.
faced, not a care in the world.
He doesn't care.
Soulless. Yeah. I mean, it's like, this is a brutal case. Like I you know, obviously there was no intent here. So like that, we're not talking about like George Pino as being a monster at all. You know, it's his culpability is what's, you know, at question here. And it's just like, I really feel for the guy. I feel for everybody in that courtroom. I obviously feel for Lucy's
I
folks.
feel for the daughter Cece because it was her birthday party. It's her family that caused the mess. Her friends died.
Yep.
So at the ripe age, she's turning 18, probably about to, you know, you graduating high school at that point in time.
Just a nightmare.
Your family and your friends group are both having to deal with this in a slightly adversarial way. It seems like the families kept in touch in some manner, but at some point there was a gag order issued where even though they'd been texting, the families had been texting, they no longer wanted George Pino to text. I think it was the Fernandez family, but it might have been the Puigs, who we're not really hearing much about because this trial is only about the deceased victim. At first, the initial
Right.
charges, there were like 3 charges relating to death or serious injury because of the 2 that have lifelong complications that did survive. But this trial is just about the 1 deceased victim.
Yeah.
And like just 18 and you like lose your friends.
Everything. Like your entire life structure has been completely upended. You know, your friend circle is like splintered. Your parents are destroyed. Everything about your life has been completely destroyed from this one horrible, horrible accident. And it's like, yeah, she's and it's not something you shake in a year or two, you know, it's just something that's part of your life arc now forever, you know, and it's just this tragedy that will always, you know, and it's obviously going to affect her in a profound way, you know, throughout the course of her life, you know, it's just it's awful. Like, you know, I'm that dad, you know, it's like literally last year we took so we went up to the Dells or went up to a sport lake in Wisconsin and we rented a boat and I brought 6, 7 of the girls, you know, of Scouts friends out and we were boating. And the
I'm in
girls
the life
were
jacket 24/7. I'm not taking it off after watching trials like this. I will be that person that has the floaties on.
I mean, I think I made sure all the girls, but they, you know, we were tubing and, you know, just having a great day. Obviously, I quit drinking years ago, so that was not an issue, but still, it's like
Love it.
I wouldn't consider myself to be a master at boating by any stretch of the imagination. I understand like the basic rules, but you know, I mean, God, like if something horrible had happened that day because of my relative inexperience in terms of, you know, because when you've got a tube behind you and you're kind of gunning it to get the girls so that they're hitting the little wake, you know, and getting some air
Like the fun of
and
it.
you know what I mean? And like if there's some terrible accident that happens with like a jet skier that somehow you know, it's like I would never get over it. It would be just like the worst thing that could possibly happen because you're just going to live with it. I really feel a ton of sympathy for this guy. Like I said, he's not your typical monster, you know, that we're watching in trials. You know, he's not a dude who, you know, killed his wife because he was having an affair or all the horrible shit that we watch day after day. It's like this is but I like these kind of cases are the ones that are always the most fascinating to me, like self-defense type cases. Because this one's almost got, you know, the feel of a civil trial, you know, even though
Yeah.
it's still got that higher burden, but it has the feel of a civil trial in terms of that culpable negligence standard that's got to be met.
Well, and that's the thing. So, can you kind of give us, because we have the manslaughter and we have the reckless vessel homicide as the two counts, both relating to Lucy. But you know, how or why would you suspect he was charged in that form if they're not charging him with the boating under the influence? There isn't a speed limit infraction, there is no max capacity, and there's no requirement to have a posted max capacity. Um, there's no requirement to wear the life vest, even though they're supposed to be available, and they were available, I believe. I'm so confused was a question. And we had two null prost counts that related to like the registration on the boat was expired. And maybe a registration comes with an inspection, like a safety inspection, but they null prost that anyway. And there was one other for some type of equipment. So, some other safety gear operating without safety gear was null prost before trial in middle of May.
I mean, in terms of kind of looking at it just on its face, I think that they realized pretty quickly that the, you know, boating under the influence was a no-go for various reasons. You know, obviously when we kind of get into what happened, you know, when they're first talking with him, you know, he never was asked to perform any field sobrieties. You know, just the investigation into that aspect was so lacking that I think that the prosecutor probably looked at it and thought that that wasn't even an option for him. You know, so there and this thing wasn't charged for years, right? Like, I mean, this had gone, and then when the Miami
So
Herald
they
started
had
digging into
that's when this guy Matthew Smiley comes forward that had never been interviewed before, who said that he went out to the boat that night and was trying to help, and that he observed that there was a smell of alcohol in George Pino's breath, and that his eyes were a little bloodshot, are some phrases that I saw from his deposition that were quoted in motions. So, but
his
that guy
eyes were
doesn't come
bloodshot.
forward
What happens if he
because he was
like
just in the water drowning and got hit in the
right?
head.
And maybe he's been crying. Like who knows?
Um,
I mean, we see
yeah,
that George is a crier, you know. I
and
mean,
They didn't interview this guy. So that's why the defense is emphasizing 8 witnesses, not just because 8 witnesses are going to say so, but these 8 witnesses gave closer to time contemporaneous accounts for somebody who didn't come forward until the end of 2024 when this happened in July of 2022.
Who
And I
was
think
this guy? Was he
Matthew Smiley, he's a firefighter.
Oh, so
who
he
saw
is
the
a first
Miami Herald's
responder.
coverage where the family was saying like, look, they botched this investigation. So then this guy comes forward and says like, look, they didn't interview me either, and wanted to speak with the state attorney's office. So, and
Yeah.
what he's saying might be, he might have an accurate reflection. He might have a perfect memory. Who knows? But there's still questions about why wasn't he interviewed contemporaneously if he had such important information to give, and he was apparently there at the time this all happened. Like, what
Yeah,
was
that's
FWC doing?
right. That is it's a very interesting question. And why aren't any of the other people, at least, you know, the people I'm going to have to figure that will have the most weight with the jury are the first responders, right? You know, the people, law enforcement that were out there, and none
I
of
think
them indicate.
Lucy's dead.
Yeah.
Like,
Because the time
it's got to
frame
be
from
hard.
when they leave the sidebar, how long? There couldn't have been that much time from when they gather all the girls up, get the boat going, they leave the, you know, the sandbar, and then they're back. Well, like how much time passes? 10, 15 minutes?
So I think they were leaving around 5:30 was when they said bye. The Fernandez family said bye to everyone that was staying on the boat. And then this accident happens around like 6:40, 6:50 is when they're approaching the
So
channel
there's
marker. It's like an hour 15, hour 30.
okay. So they hung out there for a while, got the girls all gathered up, and then made their way in. Yeah, I don't know. It's
He's
not an
supposed to
easy case.
testify. I wouldn't want to be in the position as a defense attorney to have to ask the dad of the victim those things, but you have to. So that's going to be tough to watch, I think.
Yeah, definitely. It's going to be really, really tough to watch. The whole trial is going to be tough to watch. You're just dealing with devastated families. So,
well, we've got a lot. We can skip a lot of this too once we start playing again, because they go to the wall for a while.
oh, they do. Yeah.
Yeah, look, I think we'll see them what they do here, if they like walk him out of the room or just go to the wall. I wonder if his side is wearing green, just because like they want to have color unity too. Maybe it's just a coincidence 2 people have green, because we can't really see behind them.
No.
But this whole side is wearing blues.
I mean, George is a pile of goo, man. Like there's no puddle.
How does that come into play? Like if somebody wants to testify in their own defense, but they can't compose themselves?
I
Because you
I
can't
don't
just
know.
say you can't testify, right?
Right. I mean, you're like, I don't know what the judge would do in that scenario. It's like she can't bar him from testifying if he's unable to compose himself. I don't know what the judge can do, to be honest with you. I've just never seen it. I mean, we're not robots. You know, I think the jurors are smart enough to know that people are going to have feelings, you know, and like how much weight are they giving that? I don't know. You know what I'm saying? But like, this trials are fascinating for people because it's really the whole human condition under the microscope. You know, I mean, it's like as much as I couldn't stand Donna Adelson, like I still understood why she was crying, and the judge was just not having it. You know, quit crying, and it's like it's after she's found guilty. I'm like, wow.
They took his water cup away.
Yeah, we have to stop putting liquid in your body so it can stop coming out of your eyes.
All right, then the camera's glitching again, and then I think they just go to the wall here, which we can skip. So it looks like they're gonna have to take some steps. Maybe they walk him out of the room. I don't know.
They could put up like a triboard like partition in front of him and just
No one can see.
Just like if they put a picture of him on the outside and then he's behind there.
Like I have an older brother. And
Yeah,
we
like a
used to play.
trifold partition. You know what I'm saying? It's like just
We
made
used
of
to when we play
cardboard.
Mario Kart, we would divide so we couldn't like or GoldenEye 007, we put a partition so we couldn't see where the other was on their screen.
Yes, exactly. Or it's like if I'm playing code names with Ali, like we have to put a partition in front of her because she can't not make like some kind of verbal hints or facial expression that gives away like if you play code names, you know what it is. Like you know what I'm talking. Like Ali, it's like a constant fight with the kids and
Just no
Allie when
poker
we played,
face.
she just can't do it. I'm like, you have to go in the other room. You just can't control yourself. It's like you can't. It's hilarious. Cameron, our 19-year-old, gets so pissed.
All right, because his attorney's got a green tie too, but he's wearing blue. I wonder if he did
He's
that
like,
intentionally.
He's like, I'm fine. I'm fine.
Do you think he might have worn a blue tie intentionally?
Maybe. This is a tip of the cap. Nod of respect. I don't know. He is going through it. Look at his breathing.
You know, I was outside there is when I understood it. That's right. Normally I would pull the alarm. They don't need to do reset? No.
They would pull the alarm for a crying defendant.
Okay.
Oh. Okay, this camera keeps doing that. All right, the captions are picking up something. All right. Well, if he wanted to testify, he couldn't take a sedative. But if he's just sitting there, could he have a sedative? Or would that say it's like impeding on his participation?
I think that would be like I wouldn't even bring it up with the judge. You know what I'm saying? Like the judge is gonna be like, if he's like, should I take a Valium? Like maybe that'll help my anxiety. Yeah, like I don't know.
The foresight that it'd be an appealable issue because he wasn't actively
right. Wow.
The judge is like, oh man, we're gonna have to push back this Antonio Brown hearing.
The defense rested in Carmelo Anthony.
Oh.
You know that case?
Well, it's the end of the day. Did they just rest now, or did they rest earlier in the day?
Somebody messaged me that the defense is rested in the Anthony case.
Because that's like a day and change of presentation, right? Although well,
I think they went Saturday. I don't know if they put anybody on. Like I don't know if the defense, because the state rested on Friday, right?
I think the state rested Saturday morning, and then the defense began calling at least one witness.
So yeah, I mean, I guess day and a half. Like they were talking about going all week.
Yeah, maybe. But sometimes I think that like defense attorneys will say that just so the state can't predict, or obviously to make sure.
Kat, are you trying to like tell trade secrets here?
Obviously, something caused a pivot, a necessary pivot, and
a lot of times
defense attorneys would never leave the book open.
100%, and a lot of times it can be as simple as that you don't really feel that the state met their burden.
Yeah.
You know what I mean? And it's like you didn't win on the motion for a directed finding or directed verdict, but you feel like you can trim your case down substantially. Just kind of, I'm curious if do you think Carmelo testified?
I'm going to say if they rested, probably not, because I imagine he'd be on the stand a long time.
Maybe not. I mean, it was a very 5-minute occurrence, you know? I don't know.
If we had the chat would be...
Only if we had the chat!
I have one, I refreshed on Twitter, and it's like, someone saying defense is ready to shake up the courtroom 42 minutes ago, and 27 minutes ago, the defense is rested. I wish they need transparency for this reason.
Exactly.
Yeah, scrolling a little bit, and I see that jury is being dismissed for the day for Carmelo Anthony, guys. This is not about George Pino. And called back tomorrow for closing arguments from both sides because, oh, that's a Texas case, so that's Central Time, right?
Yeah.
So it'd be about 2:56 there right now.
So
So
yeah. So
they're gonna
Bailey,
do closings tomorrow.
who lives down there, I don't know if she's in the court. She said judge thought the closing was going to be closing arguments were going to be Friday. But she says, but I think the defense witnesses kind of ruined their case. Carmelo did not testify. Most of his witnesses seemed like they were not prepped and kind of changed their testimony.
I never want to be in a position to have to choose whether I want to take the stand or not.
Yeah, good. I don't want you to ever be on like trial for some kind of murder, Kat. Like,
Generally speaking, right? But
that
like
would not
every
make me
case,
happy.
every case, especially like a self-defense case, I'm like, oh my God, would I? Would I not? Would I? Would I not? Would I? Would I not?
Yeah, I know. It's like those cases are the ones that always really grab me though. You know, it's like it's just because it's such a it's like in the heat of a moment, you know, and that's all it is usually is a moment. And just trying to figure out how the human mind's going to operate, you know, with all of us being individuals and treating things in a different way mentally, you know, it's there is no pro forma answer to that question in terms of, man, George is going through it. I don't think he's going to be able to compose himself. Like, I think he's going to keep losing his shit. I mean, maybe
this girl's like, you need to give him more than water. Look at this crispy soda.
Yeah. Man.
And he's got, you know, them little packs of tissues that you like pulled 2 out and the pack's empty already.
Yeah.
Yeah, that's not going to help.
No.
I think another thing that's scary too about the decision to testify or not is it doesn't matter if there's an instruction like you shouldn't hold the defendant's decision to not testify against them. I just feel like it's such a strong desire to hear from the accused that like it's already a likely expectation that you get on the stand and tell your side.
100%. 100%.
And
I mean, and I think, you know, it's that thing where people, when they're thinking about if they were in that position and if they're thinking, well, I didn't do this, you know, and they're saying there's nothing on the face of the planet that would stop me from getting on the stand and professing my innocence. You know, so like most jurors, if not all jurors, go into those courtrooms and get into that box with that same thought process. You know, an instruction that you can't have a negative inference by the fact that the defendant didn't testify on their own behalf does nothing.
This
It does
camera
nothing.
is zooming.
Man, it's like it's high drama. They're living in it.
Well, and the other thing too, you think like I can get on the stand and profess my innocence, but most of the time people are there because they've already spoken to the police, and whatever you believing you're innocent said to the police disagreed, and then the prosecution disagreed, and a grand jury disagrees, and by the time you get through those thresholds,
Yeah.
I don't know if you're sitting there and you're looking over at the jury, and the jury seems to, and I think even reading juror expressions can be reading tea leaves, but if I'm sitting at the defense table and I see jurors reacting a certain way, it might weigh heavily on my decision to want to speak to them or not. So,
Exactly. Yeah, that's an interesting thing. It's an interesting thing.
So
But
is she speaking over to, okay, the attorney, because that's the attorney with the green tie. I was like, who's she speaking to? But that's his counsel, right?
yeah. How much blooping time do we have?
Let's see how much they're on the wall for this. All right, it looks like he's going to be at the podium speaking in like 2 minutes.
Given my observations of Mr. Pino, it's my request that he be examined to make sure he's not having an event that could be more problematic. I don't think he's well, and I don't think he's in a condition to make a decision. And Your Honor is suggesting that I welcome the offer. I think someone should examine him. I don't think I'm competent to give an opinion about his health situation.
Did she offer maybe a mistrial, do you think? Without prejudice? Did you hear what he just said?
No.
He said, I don't know. I think he needs to be examined before, because I don't know if he's in a position to consider what you're offering.
Wow.
An event that could be more problematic. I don't think he's well. And I don't think he's in a condition to make a decision. And Your Honor is suggesting, I welcome the offer, but I think someone should examine it. I don't think I'm competent to give an opinion on this health situation.
Do you think that was a mistrial offer?
I mean, maybe.
Offered the option, I want Mr. Pino to verify. Okay. And fire rescue was already here, and he understood that there was a brief examination. We'll have them come back, but what I had offered as an option, which we have live stream right next door, and Mr. Pino is online, and he can sit there until he feels more comfortable. I'll let the jury know that, so that we can continue with our proceedings. That was the option I offered. Or we can continue, Mr. Pino still here, but if Mr. Pino felt emotional again, then it's not proper for the jury at all to be witnessing, the emotional behaviors.
Maybe the offer was
I
just
agree
to...
that the jury should not have to observe that. And so what I'm asking is whether we can have him examined before we continue with the proceeding, so that if there's a serious medical issue, that we're not just assuming that it's appropriate to remove himself to remove himself from the courtroom.
And for the record, he was asked.
Right.
10, 15 minutes ago, and if you have some concerns that, he needs that additional assistance, then we're going to make a call again and have them come. Even if Mr. Pino says he doesn't want them to come, now we're going to have them come. We're going to have a medical assessment of Mr. Pino before that proceeding. Okay. And we'll be in recess until, I would say, let's take 15, 20 minutes, and we will be back, and I'll advise everyone how we're progressing. Okay?
All right, they show him for a little bit here. If I was the state, I don't think I'd want him to be taken out of the room, because what if the jury feels bad about that?
Yeah, it's right. It's the same thing.
Like,
it's essentially the same impact.
It's like a catch-22, no matter if he's either crying in person or he's kicked out of the room.
Exactly. It's the exact same thing. It's having the same potential influence on the jury. Because if they're like, okay, well, wow, like he can't even compose himself to be able to sit in the courtroom, like whatever the judge would do to describe why he's not sitting there, and if he's in the overflow room.
Oh, if they try to explain it, it's going to be even worse.
Well, that's what I'm saying. Like, she's going to have to say something. It can't just be like, all right, we're starting the trial and the defendant's not here anymore. Because the jury, like, what is the jury going to be doing at that point? Where's the defendant? What's going on here? Why? Like, are we having the trial without the guy in here? You know what I mean? It's like, it's a really weird situation.
Well, good thing they can't just go on YouTube and look at a live chat.
Oh, thank God for that.
Oh my God. Okay, there's going to be an alarm.
Somebody pulled the fire alarm? Did somebody pull the fire alarm in the courtroom? What the?
All right, I have it cut down.
The Pino.
Oh, it's a walkie? It's Miami-Dade to something.
It's not a request.
Yeah, I'm gonna call the
I should have stayed in Miami this week.
I mean, could have been in the
There's a
heart of
lot.
it.
There's a lot happening in that courthouse.
A lot.
Oh. But like, did the camera person just fly?
What did they ask?
You're not rolling, are you? And then she said, oh, okay. And then the camera pans to the wall.
Wow. Oh, sorry. Okay.
This is a mess. This is a mess.
Man.
And I need them to allow streaming for the Rashawn Jones trial, which is going to be in this courtroom. Oh my goodness.
So what you said, when is that up? On Friday?
So the motions in limine hearing is on Monday, which I think is the 15th. Yeah, the 15th. They had an emergency hearing Monday, like a week ago from today. They had an emergency hearing added to the calendar. You know, attorneys can just go book a emergency hearing.
Yeah.
That I went down for because the judge has been shutting off the Zooms. And I wasn't like broadcasting any of the Zooms, so I was just watching. But the last hearing where there was a calendar call and then Rashawn Jones' case was called, she ended the Zoom when she called Rashawn Jones's case. So when I saw the emergency hearing booked, I went down because otherwise I wouldn't know what was happening. So,
wow.
But his retrial is scheduled for September 14th. And that will be here before you know it.
With a blink of an eye. Blink of an eye.
Trial 1 is only some parts of testimony are uploaded. Like the lead detective, there's like an hour and a half of footage and most of it's just playing his interrogation. But he was on the stand for more than a day and there's only an hour and a half of his testimony available. Wow. And the jury, reportedly, a juror spoke to the media and to one of the attorneys and said that the jury was split 5-1 in favor of acquittal. So,
wow.
Like, I think it should be televised. I think people should be able to see what's going on.
Always.
And why we're retrying something that we were 5-1 on.
I mean, you're the kings and queens of the sunshine law, I mean, it's like everything out in the open.
This courtroom must be cursed. They must think that they have so much light coming from this backdrop that that's all they need. Because it's the same courtroom, I'm telling you. It's the problem.
It's the jinxed courtroom.
Yeah, this must be like their large courtroom where they do stuff that's higher profile. Okay, I'm jumping ahead, but we must have a lot more to go because nothing's popping up. I've been sitting here tapping forward. Oh boy. Well, Bob, get to talking.
What happened?
All right, they come back.
Oh, thank God. Oh, we're going to have to really kill some time.
We went to chat without a chat.
Chatting without a chat. Yeah. Wow. So, well, his lawyer was asking that maybe he be examined
in the other room.
Yeah. She offered to allow him to sit in the other room. His lawyer then asked if he could have him a physical examination of him because he thinks concerned that there might be something else physically going on with them. Like maybe the guy's
you're not in a state to make a decision. Now, this is also interesting and I promise we'll get to it, but also interesting because a back and forth in this case is, did he make up this lie to defend himself by saying that there was a big boat causing a wake? Or is that just something he made up because the defense plans to call a witness that's going to testify to traumatic brain injury that he sustained and false memories that could be the result of that traumatic brain injury? So maybe seeing him have this physical ailment is especially prejudicial to the state because a juror could envision that could be why he's not lucid when he's remembering these other things.
Maybe. I mean, like, to me, this is just pure human emotion. It's like, it's not complicated. It's hard to explain to people that have never been in the system, especially in terms of sitting in the defendant's chair. Like I had a client and Ali and I took it to a jury trial and it was a reverse buy, 16 kilos. And like, they had come after our guy claiming that he was the lookout during this reverse buy. And a reverse buy is when law enforcement,
The confidential
undercover,
or
right, or CIs, but in this case, it was actually undercover law enforcement that put this deal together. So this deal is taking place. Anyway, we fought it very, very, very hard, and so as we're sitting there waiting for the jury to read its verdict, our client standing like he's right to my right, and like he's breathing like George Pino was breathing, just like, when you're waiting, my heart's going a million miles an hour. There's no other thing that I've ever experienced. And I've handled a lot of high stress shit, like taking the bar
waiting
exam.
for a verdict.
And there's nothing like it. So as soon as they read not guilty, my client's nose just exploded. Like he started pouring blood out of his nose because his heart was going so fast. It was crazy, but it was like a perfect representation of just how high pressured that was. It was a crazy thing, because it's like, as the attorneys, you're feeling it too. You know what I mean? Because like in that particular situation, whereas he might have been involved, he definitely removed himself from the conspiracy. You know what I'm saying? Like, he had called his wife at work. He's like, I think some crazy's going down here. Like, you got to get me out. Like, so that whole thing. And it was just, and the state's offer on that thing was like 8 years on it. And his wife was pregnant. Like, he just, like, it was his whole world was, about to collapse on him, depending on what that jury had to say. It's just a lot of stress, it just is.
Can you imagine sitting there not being able to change your clothes?
Oh my God. No.
Let's see what she says. And guys, we are like almost real time. So no more stream delay, since we don't need to delay.
Yeah.
Oh, okay, wait. She's really quiet. My volume's really quiet. Bring the jury out.
Who will bring the jury?
Okay, this is we'll go back on the record now. Jury will be coming back in a moment. We are going to suspend the proceedings today.
Oh, we're done for the day.
We will resume the proceedings tomorrow at 9:30. The question is going to be whether it's in this courtroom, since apparently, not only did we have, apparently there was a 6.1 earthquake in Cuba while we were all out there. There also is an issue with the air conditioning.
Oh my God.
As you probably could tell. And I'm not sure if it's just affecting this side of the courthouse. So, we may or may not be in session in this courtroom tomorrow, or in another courtroom on the other side of this hallway. There's several courtrooms available on the other side of the hallway. But what that would mean is, ladies and gentlemen, that we would have several other courtrooms available for...
All right!
Oh my God.
Hold that thought.
Is there a gummy bear on the floor? Oh, it's an exhibit marker. All right, so there's the jury feed again. So they might move to another courtroom. So there's an earthquake, there's the AC acting up, but then George Pino was also just crying very emotionally. And they're going to tell the jury that it might be an air conditioning issue, and maybe there is, maybe they can feel it. But if it's not noticeable, do you think the jury is going to be like, what?
Yeah. This is like what they would call a perfect storm.
I apologize for the delay, and thank you for your patience. I'm sure Renee is taking good care of you with snacks and coffee.
What do you do? Never all of it?
Keep them coming. However, we are going to suspend the proceedings for today. We will resume the proceedings tomorrow at 9:30 in the morning. I do not know if we're going to be in this courtroom or if we're going to be in the courtroom I usually use, which is 4-6. one of those two, because there apparently is also an air conditioning problem in the building, if you haven't felt it already.
Okay, I guess they can feel it.
It's the entire building or just this side. So, we have your information, but you are expected to return tomorrow at 9:30.
Oh boy.
Please be mindful of my instructions about not looking for anything or any information outside of this courtroom about this case. You have heard no evidence. So please do not become an investigator. Do not go in social media. Do not talk to each other about this case. Do not speak with anyone about this case. If anyone has a question, I'm on a jury, I can't talk to you. Those are the responses. And if there's further inquiry, you send them to me. Right? If anyone attempts to speak with you or in your presence about this case, please remind them you're on the jury. Always wear your juror badges well displayed, and even during breaks, because I think there's one main kind of eating area down the street. I don't know my bearings here, but you should wear your juror badges really the entire time that you're within the vicinity of this courthouse and you're doing your work here. Okay? If you see anything in the news, ignore it. You think you see anything in the news, ignore it. Okay? Tomorrow when you return, please return to the jury room, as we have it. You'll meet Renee up there again at 9:30. As you're leaving now, if you would please put, if you haven't already, your notebook inside the envelope, and you're going to give Renee the envelope, and he's going to store those envelopes for you. Make sure your jury number is on the front of the envelope. So, and again, the parking is taken care of. Renee, if there's any other instructions, you can speak with them. And again, tomorrow, 9:30, jury room, 7th floor. Have a pleasant and restful evening.
All right, bring your yellow envelopes with you. Follow me.
And I think the stream's gonna end, but we'll make sure. So, I don't know, I kind of have a feeling that trial itself might be up in the air tomorrow.
Yeah.
So,
I mean, I think, he's not in custody, right?
no.
No. So, like, I think he might end up going to the doctor. Like, he could have had some kind of myocardial issue. Like, I mean, I don't know.
I was in the middle of it, but I think you got the rest of it from when I was explaining to the jury. So we're intending to continue with the proceedings tomorrow here at this courthouse, unless I hear something else.
Unless I hear something else.
In terms of providing that information, as soon as I get the information, I'm going to extend it and make sure the attorneys and everyone knows. But I'm hoping to be back in this courtroom tomorrow. If not, we're going to make arrangements if we can hopefully stay in this building to work on the other side of the building. And we'll set up several courtrooms if needed for whoever wishes to be present. Might not be in the courtroom we're working in, but you'll have the entire proceedings. You'll be able to observe them through the live stream. So I expect that that's what's going
Can we re-enable the chat?
And I hope you all have a
Bob, let's re-enable our chats.
Okay.
Oh my god, this is gonna be fun. It's gonna be like a stampede. I think we can do that, right? Let's go find
I don't see why not.
Today we learned.
Fire chambers.
All right, it's hard like that.
Thanks. Oh my god, come back to the chat, guys. see who
You're
gets
free.
to the first. Who comments first. Oh, I think Sharon was first, right?
Wait, let me see. I haven't seen anything pop up yet.
Oh, it's not coming through on StreamYard. I have to look through it on the...
Oh.
Which means I won't be able to pull them on screen. Maybe it'll catch up in a second.
Oh, yeah. There they go. They're in here.
Oh, so I see you through YouTube, people. I see Sharon. I see Factual Lie yelling freedom. Who do you see over there?
All of them. Sharon, Brian, Living Story World, DJ Walker, Yurgal, Jeremiah, Alex, Melissa, Wildside, Brooklyn, Palmyra, Christina, Lawsy C, Bailey B, all the peoples, Fire Lawyer. You guys survived it. Now
Amanda
you know.
says free the chat. Nerdy Girl says we're back. Jersey Girl Trey says we're back. Medina Finn says why was the chat disabled? Court ordered, and we didn't want to. Although we think that that's not really allowable, we didn't want the stream.
Yeah. Or I mean, worst case scenario, we didn't want the the whole stream to get cut.
Yeah, you wouldn't have, and then we wouldn't have been able to see what. Like, can you imagine if there was no feed and then we heard that everything recessed for the day? We would have been sitting here like, what happened? Because when there's no feed, sometimes the reporting doesn't really tell you.
Yeah, I know. Well, I mean, it was, so we got through half the openings in about 5 minutes of the defenses before, a very unusual thing happened. Like, there's no question. I can't say that I've ever seen opening statements in a trial get delayed based on the defendant breaking down emotionally to the extent
kind of broke down in like, I don't know, in an unexpected place, I think.
I think I don't like what is unexpected, like there is no
it just happens.
He's feeling all of it. Like this guy is feeling like this guy feels like shit. This dude isn't walking around like, oh, it's no big deal. Like this guy has been feeling this for 4 years.
I found a cheat code to get the chat on screen. Don Burke, thanks for the gift. Let me pull up your stream so we can toggle. Chat, we are trying to free you. We are trying to get you
the chat.
included.
Free the
Let
chat.
me find you. Oh, Defense Diaries.
Free the chat.
All right, Defense Diaries, you're about to be pulled up on screen, so get your comments ready.
Oh, yeah. Oh, yeah.
Well, let me mute because I have like 3 of us talking in the background.
Unchained.
I don't want to hear my own voice. Okay.
Free the chat. Oh, yeah. Team Ali.
Am I in your chat?
Yeah, that's my chat.
Did I go to your feed instead of?
I think you're in my feed.
Okay, never mind. Cat Williams chat, get ready. I pulled up you twice, and
thanks,
I then
Cat.
realized it was the same comments, and I'm like, is everybody just in both places repeating themselves? That's very kind to make sure everyone can be included.
Indeed, it's super
All right.
inclusive.
Let me queue up because I got to resize it right, otherwise, the video itself will block us. Oh, there's gifts. You guys are so nice giving gifts.
What do gifts do? Like, I don't even understand. What do those do?
Oh, it's membership, so people can use the. Oh, you mean the little gem thing? That's like a new feature.
Yeah, what are those?
It's like a sticker, but I think you have to be on mobile to send it.
Oh, okay.
See, I can't highlight anything. I can't. It just has to be. Oh, there's us. Okay, wait. Let's find. Look at that. We have Kristen Vasquez with the 5 gifted. So we've got Carolyn Taterville, Terrence, Pensive Peggy, great name. Medita, oh wait, no, you're just chatting. You've been green. And then we have Ipsy Dixit's, great name, and Chaos getting a gifted membership. And then Sheriff Chuck, I see the party Chucks in the chat celebrating. Giving gifts to Nurse KL, Krista, Emmy L, R. Bauer, and there we go. Medita got a gift from Sheriff Chuck. So thank you to Kristen and Sheriff Chuck.
Big time.
Let's get them real time on the, look at all the lemon pound cakes. Look, everybody's just happy to be live.
I know.
All right, guys. Now that we have chat live and we've celebrated you guys being back with us, what are your thoughts on this case so far?
Yeah, we
Well,
want to
we'll do
hear it.
some toggle back and forth.
We want to hear it. Like, what are you guys thinking? What are you guys thinking so far? I mean, at this
So-
point, we've heard the state's theory, and tomorrow, hopefully, we'll hear the defense's theory.
Eventually.
Maybe, if he's good to go, if he physically is cleared. I am absolutely, if I'm his lawyer, I'm telling him he's got to go get a checkup.
StreamYard's pulling again.
What do you mean?
It finally, StreamYard's giving me comments again.
StreamYard. Oh, it is? Oh, yeah.
Yeah, they just started coming in. But you guys are on the screen. We're not taking you off the screen. You guys are all on the screen today. Oh, it's not scrolling live.
Wow, Brooklyn's going into the Wayback Machine. She's thinking Natalie Wood. The old Natalie Wood case, yeah.
Wait, what case was that? That sounds familiar.
Natalie Wood, like she died in a boating accident. Like she was like an actor in like the 40s and 50s, I think. It's some old-timey stuff.
Yeah, I don't know. I mean, Carol, question of the day. I don't understand. It would be a violation for a juror watching the trial at any point. So what does it matter if there's a live chat? It's
I don't
know.
I don't understand it either. It was a red
and-
rum, Brian says, with Natalie Wood. Oh yeah.
Oh, like it was
Robert.
a murder charge, like they thought it was intentional.
Yeah.
Like a crash or like a thrown off the boat.
No, I wasn't saying that was her age. I was thinking, when was that? When did that happen? The Natalie Wood murder. Let's see.
Yeah, Michelle says he said she fell overboard. Oh, I would never want to be in that position because who's going to believe you? Like.
All right, so let's see. Oh, that was all the way in 1981 at the age of 43 while sailing off Catalina Island, California with her husband, Robert Wagner, Brainstorm co-star, Christopher Walken, and yacht cap. Ooh, Christopher Walken was on there. And the yacht captain, Wood fell into the Pacific Ocean. Initially ruled an accidental drowning, the ongoing investigation and reclassifications have kept the case in the public eye. I mean, so there were Wood, Wagner, and Walken had been drinking and reportedly arguing before retiring to their respective areas of the yacht. The Splendor. The disappearance
So
of
there was a theory of an argument.
Wow.
Like motive, bad blood.
The case was reopened in 2011. Reopened the investigation after the yacht's captain claimed he lied in the initial statements and that Wagner was responsible for a heated fight that preceded her disappearance. Huh. By 2018, investigators officially named Robert Wagner a person of interest, citing that he was the last person with her and the sequence of events leading up to the 911 call did not add up. Wow. Huh.
We're going to have to do like a boat series marathon.
Death on the high seas.
Stuart says, hey, Kat, what did you say the investigating lieutenant's specialty was? I'm behind on your live stream, but didn't catch what you said during the state's opening. Yeah, because the state didn't want to say it and was like, oh, they got promoted, which I don't know why she'd emphasize that as well, because I think the investigation was lacking. So why would you emphasize that he was promoted? Because that kind of gives him credibility for what he investigated. And he decided there was no impairment. But from motions from the defense, the defense represents that he was a certified drug recognition expert at the time. So this is your lead investigator who found that that impairment was not a factor in this elision, saying that he observed no signs that Mr. Pino was impaired by alcohol, and he presumably would have been trained at the time. And then as the trial proceeded and they wanted to add this manslaughter charge with this culpable negligence theory, although they're not charging a BUI, boating under the influence manslaughter, the state at some hearing had done a line of questioning where, well, you weren't observing George Pino until like an hour and a half after they would have left the sandbar area, meaning, right. And then he opined that the blood alcohol could dissipate at a rate of like, whatever he said, like 0.05 or something an hour, like one beer an hour could dissipate from.
Yeah.
And so basically they had this guy, it's like they didn't want to recognize him as an expert, but now they're trying to find a way to weaponize his training. To say why they couldn't get evidence.
And like, what type of beer? I mean, George looks to be 200 pounds, somewhere in that area. Like 2 beers, like what are they? Miller Lights? Is it, an IPA with
Some of those IPAs are like almost
big
double
time,
digits.
huge ABVs? Yeah, I mean, some of them are like 7, 8s, 9s. Like I've had back in my drinking days, I drink like 2 of those things and I'd be pretty hammered. But I'm guessing these were just like shitty boat beers. You know what I mean? Like Miller Lite, Coors Light, that kind of shit. So I don't know. I think it's going to be a tougher case for the state to get where they need to be. To me, it's got the feeling of, the emotional narrative verdict is what you fear if you're the defense, that the jury
That
just
they
feels so bad that
They
they
feel
just,
bad that someone lost their life, and this is your
yeah,
opportunity to say it was avoidable, it was
right.
preventable.
Exactly. Even if they don't meet the burden, I don't know. We'll see.
And
We'll
I don't know. I think
see.
I think it's kind of rough that there were so many people on that boat, because that boat just looks small to me.
It does to me too.
And I don't know if I don't think I'm like the most confident with being on a boat in general, but I feel like being on a small boat with that many people would make me feel kind of like
Unsafe.
I'd be on there with my life jacket. I would have the jacket on the whole time.
That's a lot of people on that size boat. Like that is not a
Mhm.
huge boat. And like there's X amount of seats. You'll have the seats up in the front of the boat, and then you'll typically have maybe a couple like behind where he is stationed in terms of operating the boat. Like you'll have one opposite of him, usually, like another captain's chair. I don't know. It's just, yeah, I'm just curious as to what really happened. Like somehow he missed seeing the channel marker. Like I think that there's no question that he didn't see it until it was too late. The question is how. Like I'm not buying that it was because he was shit faced.
Well, and I don't think he saw it and then tried to maneuver, because there's no indication that he tried to maneuver. That only came from the reconstruction.
Yeah.
That idea that someone tried to swerve out of the way. I don't think there's any indication that the brakes on the boat were hit. I think the slowdown, the state, at least what the state's been presenting otherwise, is that the slowdown occurred after the collision. I'm going to call it a collision.
Wow.
I can't wait. In real life, I'm going to go to somebody when they talk about hitting something that's stationary. I'm going to be like, oh, you mean an elision? And I'm going to like show them the new words I learned.
Yeah, I heard him say that. I heard her say that, the prosecutor, during her opening, in elision.
At least she described it. At
Yeah.
least she described it.
Yeah. Yeah.
Also, Kristen I think his crying was a manipulation tactic.
No way.
See, I personally do not think that about this situation, but I
No
do think
way.
that that's a thing that can happen. And I do think that some of the 6 jurors might think that, especially if they were taken out of the room and not able to see the rest of it. Now, is that prejudicial then?
I think it is.
Because if you were
I think
removed,
it's prejudicial for everybody, because you don't know which way it's going to prejudice people. You know what I'm saying? Like you can make an argument for either side that it's prejudicial. For him, you're going to get the Kristen Velasquez's of the world who's like, oh yeah, what an act. Sure, buddy, keep on crying. And the reality is like that dude's going through it. Like that's. I don't know if Kristen wasn't in here when I was explaining. Like there is nothing like sitting in the defendant's chair when your life is hanging in the balance. And believe me, even if we're not talking about a life sentence, if you don't think that whatever period of time he would be incarcerated just destroys his life, and I mean, he's going through it. Plus all the overriding guilt that I guarantee.
I think guilty people can genuinely cry in court too, right? Like the crying might not even mean, like someone could cry because they know this is over for them. Someone could be crying because they feel helpless. Someone could be crying because this was tragic.
Donna Adelson, like she knew her shit was done, right? I mean, she's feeling sorry for herself, because like she's been found guilty and she knows she's going to die in prison, so she's crying for that reason, or you're assuming. But this guy, I can't think of a more inopportune time for him to break down than during his attorney's opening statement. You
So
know,
now
like,
the jury like got to hear prosecutor, and then they go home, and that's what they've got to cook on
exactly.
overnight.
Like I just don't think that was
Oh,
not something that I think was cooked up. I think that he was definitely just feeling all of it. All the feels were going on, and he just lost his shit right in the middle of it. I mean, he's going to be a mess throughout you can tell he's going to be a mess. It says Katt's chat is convinced it's an act. Cat, what is
oh,
going
let
on?
me switch over. Let me switch over. Fight chat. Fight chat.
Fight, 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 fight.
We got like fight night going between the two chats.
And we all love due process. That's it's like
Heck
both our
yeah.
channels, big due process channels. Yeah, that's
Well,
crazy.
it was important. I had to get the due process. Otherwise, it would not have felt like a defense diary
I
stream.
love it. I love it. I love it. I love it. Yeah, let's see. Is that your chat? We stand behind Kristen Vasquez.
Hold on, wait.
He was in full panic attack mode. That's what I think was going on. See, I was mostly listening when I was at work. Thanks for joining. Donna was definitely crying because she was cooked. Yes, yes, yes. Yeah, I mean, I think it's an authentic act. Wait, what do you mean? Explain the word act for me there. Yeah, I just think he was overcome with emotions. It just, oh my God. The didn't see any tears bullshit. I hate that. We weren't close enough to see tears.
I think dry heaving is a thing.
Yeah, he was definitely
I've
having.
ugly cried without some tears.
Oh yeah, for sure. For sure.
And it is a gross sight. It is. And I'll have like snot. Like my sinuses will be going and it'll just be like not pleasant there, but it won't be like a waterworks from the eyes sometimes, depending on the type of cry.
Yeah, that
Good
guy.
old ugly cry.
See, that's the thing. Like our chat is the perfect example of the jury. Like to what you were asking, like who is it prejudicial to? It's prejudicial theoretically to both
All
sides.
over.
Everyone, because there's going to be people who think he's full of shit. But like I'm saying again, he's not like the monster. Like there clearly wasn't an intent to do this. Like this guy is like, you have to know he's got an 18-year-old daughter that he's celebrating his, her birthday. And, the parents tried to put together this magical day that just turned into a nightmare. And like, this guy is, I guarantee you, just like feeling as low as a human being can feel, I mean, like literally these are kids that grew up together and it's a whole thing. It's a whole thing. Yeah, there are.
I'm doing a poll. Don't come over here just to vote. Bob's got to do his own poll. You have your own district over there, Bob.
All right. Is it crying? Crying genuine?
I did. Was he really emotional? Real acting?
Okay.
It was 50-50 with the first 15 votes.
That's outrageous. Let's see.
It's so funny because, I mean, we kind of because when we were about to start this stream, we already saw the thing about the no live chat and we're like, okay, we'll just delay the stream. But initially I was going to ask Bob, like, hey, do you guys want to combine the chats and do the chats on screen? I didn't even ask that question because the chat was like a problem for this court proceeding. But we could really have the chat on screen fighting.
All right. So we're 22 votes in over here, 24 votes. Was George's emotional outburst genuine was my question. Currently it's 89% yes and 11% no over here with 29 votes in so far.
Oh my gosh.
Yeah.
Oh my God. We are the law and crime chat today.
You are
Pat
the law and crime chat. What?
Because they can't have one.
Wow. You guys are the court TV / law and crime chat equivalent today. And that, sadly, is not a compliment.
Let me show this. Let me get real time on your chat. Katie says rock the vote.
All right. There was a small dip. We're 57 in. It went down to 86% yes, 14% no.
I'm at 63 and 37 with just
Wow.
35. It looks like the votes have not come in
Jeez.
anymore.
What's up with all the pessimists in your chat? Man, that's crazy. That's crazy.
Let us have our day. Let us have our day. We usually get yelled at like, oh, this chat is so friendly to criminals. Let us have our day.
Oh, that's hilarious. That is hilarious. Uh-oh, it's shrinking. 72 votes in.
Aw.
75 votes in. It's 84-16. It went down to 83. It went back up. Wow. It's really, it's
Did
fluctuating.
you have a spike in your concurrent viewers? Did my chat just go over there to rig the vote?
Yeah, probably. Probably. That's what's going on. You guys are coming over here to skew it. Oh, man. They're coming over to skew.
Oh, that's a good point. Okay, Jimmy says it wasn't as bad for us workers and lurkers, like those who just be listening in the background anyway and not able to have the chat up.
That's true.
So yeah.
That's true.
You know, I was watching an opening statement, and I might actually, maybe you want to join. I was going to see if Happily Angry Lawyer would be available to co-stream. It's in front of Judge Scott McAfee in Georgia, and it's just like a Fulton County defense case with Nicole Fagan, who many people may call YSL Nicole. And I always forget the other attorney's name. And then prosecutor Gautam Rao, who's a familiar face if you follow anything Happily Angry Lawyer streams about Fulton County. But there's like this trial where someone was shot and killed in a car. In the state's theory, it was an armed robbery, but the defense, it's two co-defendants. The theory is, you know, they've got he had nothing to rob. And it seems like maybe the girl that's a co-defendant might have been going up to turn a trick with the guy or meet up with the guy, but the guy was like exposing himself when she walked up to the car and she started screaming. And the defense's theory is that this other guy ran over and shot the guy in the car while exposing himself to this girl. That's all I caught of the theory of the case. But I was listening because I was preparing for the stream, so I couldn't see the stream at all. I couldn't see what was going on with the state's opening statement. I just heard the state saying, and you could see clearly the evidence will show that these individuals go up. You could see them doing this in the car. You'll know that this person was in the car and this person was not near the car. And I'm just taking it at face value, listening to it as she's describing it. And I pull up the screen and it's just this big pixelated blur. And I'm like, whatever she's saying and I'm taking in verbally, now that I'm looking at the screen and what she's talking about, the exhibit that she's talking about, I can't see what she's telling us we can clearly see. So I always wonder now, like the working and lurking experience could be a little bit different than actually being able to see.
Yeah, for sure. 100%.
But yeah, hot mess Fulton County trial. What else is new?
All right, Larisha was yelling at me saying I was ignoring her. She said, thanks. I went to a mass yesterday. Google Melanie Hire Doral, Florida. Incomprehensible. How do you take a knife to your two daughters? I knew her ex, but she didn't tell me her ex was a psycho. Wow.
Wait, is that like where the mom and the kids were killed by an ex?
It sounds like
I think I heard, because I can picture like the picture that the news story used, like the mom was with two girls and they were dressed up maybe like an Easter event. Their dresses were floral print. That is really sad.
Oh my God, Larisha's saying, she's like, I feel guilty. She came by my condo a bit ago and I was busy on the phone and I had to be somewhere and I didn't have time to say hello. Honestly, I can't think about it anymore. Wow, that's all right. That's
survivor's remorse is a real thing too. And that could be the type of thing that, you know, anybody that was part of this boating trip could be experiencing the rest of their lives. Or like, imagine being Lucy's parents and knowing that you drove that boat away.
Man.
Like,
yeah. I mean, that's what I'm saying. Like this dude is going through all that shit. You know what I mean? Like he's literally going through it massively. Massively. You know, I just, people like these aren't, when we're watching these trials, this isn't like a TV show. Like these are actual people with actual lives that were ruined. And it's just, I always find it crazy that people are like, oh, I mean, like we're not talking about Murdoch here. Like Murdoch, you know, I can see people like, oh yeah, he's full of shit.
Yeah,
You know,
I don't really think I've watched my chat. Have we watched like an accident type case like this? But I don't really think I'm usually like the accusation is like something premeditated or it's like a weird, bizarre civil free speech trial like Afro Man.
yeah,
So
yeah. All right. So what time are we gonna go live tomorrow?
I think we should at least do like an hour and a half delay. Maybe do you want to do a clean 2-hour delay? Because they're taking a lot of breaks. I don't anticipate that will be breakless. And we'll
All
have to
right.
make a determination about chat. I don't know what we're going to do with chat, but we'll see what Law and Crime says tomorrow.
Yeah.
Um,
Yeah.
but
Maybe
I do think if we give some time in the morning anyway, there could be a development. And I'll tune in, guys. So just because we start late, I'll tune in to check, like, is there going to be a seal on the wall? Is the judge going to come into the courtroom and say, hey, we're actually going to wait till noon because we're sorting out some issues with the building? So there's nothing happening on the record with the trial, but we have something that's delaying the case until a late start today. And then I can get in touch with you. But I think we should plan to at least start late.
Okay. All right. So yeah, just text me. Ali will be with us tomorrow. She's flying in. I just found out that her flight's delayed 3 hours, which sucks.
Uh,
So now, yeah. So now she's getting it at 9 as opposed to 6:50, which is a bummer. But she'll be definitely hanging with us tomorrow.
Looking forward to it.
Yeah, it'll be
Especially
great.
if we have bloops.
Blooping, bloop, 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 bloop. She's big blooper. It's big blooper, my wife. All right.
Oh, wait, Kristen says, by the way, thank you for the 5, Kristen, but I think this is for Bob saying, I've been here. Where's my Johnny's? Sounds delicious. You guys look like you had great food when Runkle was visiting.
Oh yeah.
And no L in my last name. So did you say Velasquez when you were Velasquez?
Oh,
when you were
Vasco. I
speaking,
don't
Kristen?
think so. Maybe I did. Freudian slip. Maybe.
No L's, only W's.
Kristen Vasquez. Yeah. I don't think I said Velasquez. Maybe I did. I know a couple of Velasquez's, so it's possible. It's possible.
I used to say
Yeah,
Vasquez my
Johnny
whole life, and I had to learn to say Vasquez.
Vasquez.
Because I'm horrible with names, and I don't mean any offense by it.
Yeah, me either. I like anybody who listens to any of my Massachusetts coverage for any of the town names. They know. They know. I will butcher some names, town names, people names. It's all right there for me. All right, let's roll. Let's bounce.
All right.
Let's dip.
So let me say a final thank you here, Sheriff Chuck, for the 10, saying not pessimist, just realist with the 10. Thank you, Sheriff Chuck. You know, usually you just give gifts in silence. It's good to see you. Super chat. Thank you so much.
Sheriff
And
Chuck
Kayleen
was
says,
like
new
crushing
member.
the game today. Frankly, he was giving till it hurt.
That's why we have party Chuck emojis in the chat.
I mean, Party Chuck is pretty appropriate. He's crushing it. That's fantastic.
So my poll over here is still at 67 and 33%, even though 20 more votes have come in. So that's where I'm hitting the end poll button.
Mine went
split.
down to 77 to 23 with 118 votes. So
Wait,
they're
what
not
does
too-
admin show video on one channel and chat on the other channel? Oh, you mean so we'd have like Streamception where it'd be me and it'd be like an infinity mirror, I think, if I did that. So I don't think that'll work. But-
Infinity mirror.
So guys, plan for, and I'm East Coast and Bob is Central Time. So when I say a 2-hour delay, court, I'm assuming, is scheduled to start at 9 a.m. if all goes well in Florida. This is an East Coast trial. We're in Florida. So if we're starting late, that would be 11 Eastern Time, 10 Central. And you West Coasters, that's like bright and early. That would be 8 o'clock for you guys.
Crack. I mean, not as
guys in
early
the-
as it would be. It would be sick.
Yeah. It's a little break. So let's do a 2-hour gap, but I'll post updates that I see and confer with you. If we do find out that they've got to like move the building and they're going to waste half a day, we would start later than that.
Yeah, for sure. For sure. All right, you guys, we love you. Thank you so much for your generosity. We're so sorry that we had to shut down the chat. Kat and I both were feeling that deep in our feels. There's
Look
no
at the
question
chat
about it.
correcting us. This is why we need them.
Judge said 9:30. Okay. So it's a little later or
You wanna do
earlier.
like 11:30, 10:30.
Okay. All right.
Well, 10:30 Central, 11:30 Eastern.
Okay.
So 2 hours
Cool.
past local time because we'll skip the lunch break either way.
Yeah,
So
for sure.
sweet. All right, I'm gonna hit the end button.
We love you guys.
Missed you so much, chat. Thank you
So
so
much.
much for coming back in here to celebrate when the chat was revived, and hopefully
Free
we
the
get to have
chat.
you guys. Yes, free the chat.
Free the
And thank
chat.
you, Bob, for hanging out with me.
Oh, thanks for having me, Kat. I loved it.
Bye, guys.
Bye.